10:30, we are ready, my lord. Only thing, my lord, another similar matter, your lordship recalls, your lordship has passed an interim order in our favor that is being tested in the appeal court. Now, my lord, one of the points that they have taken there is that no application was moved. So, my lord, we have prepared the applications to be on the safe side. My lord, can it be my lord, the out commissioner sits at 10:30. We'll get it affirmed. Your lordship's officer may give leave to tag it along with 11:30 matter.
How it can be?
At
You
least,
get it adjourned.
no, my lord, all the properties will go in the meantime.
What can be done?
Very well. Let me file. We have a supplementary
If you
affidavit.
affirm the affidavit, come, we'll see to that.
And my lord, the supplementary affidavit is also there.
Okay.
So, my lord, even if the applications are not taken on board, at least the supplementary affidavits will be there.
Okay.
My lord, may I believe you will also mention this matter, my lord. This contempt matter is due to appear tomorrow, my lord. Due to urgency, my lord, at least that should be upgraded, my lord. That was
What is the urgency?
that was heard out on 1st of August, your lordship, my lord. And alleged condemners 1 to 13, my lord. They were upon arrest. They came before lordship, my lord, and they failed. None of them filed any affidavit of compliance, your lordship. Due to that reason, at least that should be upgraded, your lordship, tomorrow.
So what has happened?
Happening at least they did not. Neither of the parties file any.
इसमें नहीं है क्या?
That will tomorrow, your lordship, my lord.
It is a non-commercial matter. It will come on Friday.
Yes, that reason, my lord. Let it be upgraded on to tomorrow, my lord.
My lord, may I take a leave to mention, my lord, the item number 202 of the today list, my lord. This matter was today fixed for witness action at 3 p.m., my lord. But matter has appearing as a non.
No, it is to be mentioned में नहीं लाया क्या?
Item number 2.
Item number 2 तो.
Item number 2. 202. Huh? 202.
Oh, yes. Because I cannot do because I have been assigned with the appellate side matter. I have to adjust. That's why I have taken out from the witness section.
My lord, for any other day, kindly fix, my lord. So any other day, my lord.
Who is for the other side?
Actually, my lord, this is the expertise. 120 days has lapsed, my lord.
No, but other side
is appearing, my lord. They every time they have appeared and said they are filing this order 7 rule 11, my lord, but matter is still not on board, my lord.
Though the list में है, though the matter is listed as though the matter is listed at serial number 202 in the days list, but the learned counsel for the plaintiff has mentioned the matter and submits that by an order dated 13th August 2025, this court had fixed the matter at 3 p.m. for witness action on 11 September 2025, but today the matter is listed as in the normal list at item number 202. Accordingly, prays for fixing a specific date and time so as to enable the plaintiff to examine the witness. In view of the submission made by the counsel for the plaintiff, let the matter appear on 2nd December 2 p.m. for witness action.
May I be permitted to mention? In this matter, my lord was kind enough to pass an order directing to put deposit cost within 2 weeks, my lord. My lord, in the cost title, the name is written as PANASAN. That should be PANASIAN. Now I went to the PANASIAN.
Because of the cost title, they are not accepting.
No, they are saying that they will be accepting in this name only, PANASAN, the cost.
Recorded on. So what is the correct on name?
PANASIAN.
SI will come.
There will be on I.
Counsel for the plaintiff.
I am for defendant.
Counsel for the defendant has mentioned the matter and submits that in the order dated 8 September 2025, the name of the plaintiff in the cost title is wrongly recorded as PANASAN. Impex 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 Private Limited instead of PANASIAN Panasian hoga Impex Private Limited. Impex Private Limited. He submits that as the cost he prays for correction of the cost title. Correction of the name of the plaintiff in the cost title of the order dated 8 September 2025 so as to enable the defendant to pay the cost in the department. In view of the submission made by the counsel for the defendant in the order dated 8 September 2025, the name of, in the cost title, the name of the plaintiff shall be read as PANASIAN Impacts Private Limited instead of PANASIAN Impacts Private Limited. This order may be incorporated with the order dated 8 September 2025. 2 weeks is over.
No. This Monday, my lord was pleased. If my lord uploaded the order course of the day, I shall deposit.
Today.
My lord. If I-
करके भेज देना मेरे को लंच में भेज दे.
We are permitted to mention a matter. Item number 115 of today's list, my lord. I have filed an application for acceptance of my WS. My lord, kindly find.
Where is our WS?
The WS is affirmed. My lord, it is annexed with, is filed with the department, but it's not accepted.
Filed with the department with the leave of this court.
That is
So,
the reason, my lord, I filed the
120
application.
days is over.
No, my lord, it is
So?
expiring on 3rd October.
Third of, where is the written statement?
My lord, written statement is affirmed, my lord, whenever the matter
Bring
is.
the written statement, file in the department.
All right.
Bring the written, where is the written? Come tomorrow with the written statement. Affirmed written statement. And that will be filed with the leave of the court. Then the application will be taken up for hearing. Then we'll see to that.
My lord, I am mentioning one matter, restoration application, my lord. Though it's a PLA application, my lord, but dismiss for default occurred in this court, my lord. Earlier I have mentioned in code number 40, but they asked me to mention in this court.
Which court you have filed?
This court I have filed.
This court you have filed.
Yes, my lord.
So, अच्छा तो non-commercial है.
My lord, I'll just indicate your lordship.
Yes, next.
My lord, may I be permitted to mention item 158 of your lordship's commercial list, my lord? My lord, I am for the plaintiff. The written statement has been filed by the defendant, my lord. May it be taken up any day for further orders, my lord, so that we can proceed with the
Commercial matter.
commercial matter.
कर दो उसको to be mentioned में लग. To be. Inform the other side.
Yes, I'll give. Sure. Deeply obliged.
Yes, call the list.
For judgment, item number 1.
The leave is revoked, so it is dismissed.
Item number 2.
I appear for the defendant.
I appear for the plaintiff petition.
Refer to the arbitration.
You are appearing item number 2 for respondent.
Arbitration refer. Arbitration refer. Lord. The GM not stands according to disposed of. The GA lordship has mentioned. I'm grateful to Lord.
To mention item number 3.
Item number 3, your lordship, I appear on behalf of the plaintiff. I'm only humbly seeking your lordship. This is only with regard to service.
Which one?
Lordship, item number 3.
Yes.
Your lordship had passed an order dated 3rd of April 2025 in this matter. Your lordship directing service through the embassy, paragraph 6. Your lordship, thereafter we had obtained a report from the sheriff department on 10th of April 2025. Lordship, which shows that the defend numbers
3, 4, 5, 6.
3, 4 and 5, 6 were already served
Delivery
by way
confirmed.
of delivery. So if it commences to your lordship, because your lordship has directed the again service through embassy, since the report shows that it has already been served, subject to what falls from your lordship, probably service through embassy is not required. So if your lordship is minded to deem
There
it
is 3, 4, 5 and 6. What about the 1, 2?
1, 2 have entered, your lordship,
They've
they've
entered
also filed a
appearance.
written statement.
I'm appearing on behalf
You
of
are
the
appearing.
They've also filed a written statement.
Yes, record an order.
Only with regard to 3, 4, 5, 6.
This matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. He submits that by an order dated 3rd April 2025, this court has directed the plaintiff to take appropriate steps for lodging fresh writ of summons upon the defendant number 3, 4, 5, and 6 through the embassy within 3 weeks. The learned counsel for the plaintiff submit that after the order passed by this court, the plaintiff has obtained report from the Deputy Sheriff of Calcutta of this court dated 10th April 2025, wherein it reveals that a writ of summons through the postal services was served upon the defendants number 3, 4, 5, and 6. Full stop. Let the report be kept. Let the copy of the report be kept in the record. He submits that as the writ of summons through the postal services have been served upon the defendant number 3, 4, 5, and 6, and as such, he prays for dispensed with. He prayed for dispensing the plaintiff for lodging fresh writ of summons
through the embassy
for service upon the defendant number 3, 4, 5, and 6 through the embassy. Had the learned counsel for the plaintiff perused the report of the Deputy Sheriff of Calcutta, this court find that the writ of summons have already been served upon the defendant number 3, 4, 5, and 6 through speed post, which has been duly confirmed by the report dated 10th of April 2025, and as such the lodging of press writ of summons for service upon the defendant number 3, 4, 5, and 6 to the embassy is dispensed with.
grateful.
And item number 2, my lord, our
Let the matter appear on 18th of September 2025.
Grateful. Lord.
इनका respondent आपने बताया है।
अरे railway.
You are not appear. You are argued the matter and Section 8 application.
Our appearance has
No, railways is not a party. I think my friend is mistaken. Railway কোথা থেকে party?
dolphin তো
No.
dolphin তো
আপনি হয়তো
item
আপনি
number 2
রেগুলার লিস্টে আছেন এর কমার্শিয়াল লিস্ট ফলো হচ্ছে
Item number 4.
Your Lordship, this was our application.
I appear on behalf of UCO.
My lord, I had taken instructions from the bank last day. My lord, I had sought for 2 days time to inquire whether the bank would be in a position to, my lord, disclose these documents which they are seeking. My lord, I have got the instructions now. Bank would be in a position to disclose, but they need some time. My lord, it's old record. They're tracing out the documents. So, my lord, I was only praying this. My lord, if Lordship is kind enough to give us one more date and keeps it under the same heading on Monday, we would be in a better position. My lord, we have told them that it's fixed on 17th for witness action, and so we are trying to expedite it. If Lordship keeps it on Monday, we would be in a better position to indicate whether the documents are there or not. And if it's there, my lord, we'll bring it on Monday itself.
Your Lordship, if you could record that in the order, because your last order on the 23rd of July, it's been a long time. We have in fact given them this notice on the 15th of July, and the cross-examination is to continue on the 16th and 17th, for which we require these documents.
By an order dated 8th September 2025, this case was
My lord, I'm choosing not to file an affidavit.
8 September 2025, this court has adjourned on the prayer made by the counsel for the defendant for taking appropriate steps, whether the defendant bank will be able to produce the document or not. When the matter is taken up today, learned counsel for the defendant submits that he has instructions that the bank will produce the said document, but he further requires 2 days time. Accordingly, for the interest of justice and as a matter of last chance, the case is adjourned. Let the matter appear on 15th of September 2025 under the same heading.
Grateful.
My lord, instead of saying, my lord, that it, my lord, instead of recording that bank will produce, my lord, my instruction was that they are tracing out the documents. If I get it, I will definitely produce.
Counsel for the defendant submitted that the bank is tracing the document. Okay? And if it is recovered, they will produce this.
I'm very grateful, my lord.
Your Lordship, they've also chosen not to file an affidavit if that can be.
No, I have, my lord, I'm trying to expedite the process. I have never said I will not file an affidavit. If my learned friend wants, I can take a direction for affidavit. This will only delay the process.
Next.
I'm the decree holder, Lordship.
Not corrected, go through that.
Lordship, I'm appearing for the decree holder. I'm seeking prayers in terms of column A, prayer and A and B, Lordship.
Yes, Mr. Sinha, what is your instruction?
Lord, unfortunately, Lord, from the state, Lord, nobody is able to Lord, take
Any
it.
state?
No. So that's what I'm saying, Lord, your Lordship, Lord, can proceed, Lord. I only thing my learned friend, Lord, is asking for attachment. But I was not suggesting, Lord, that the state be directed to not pay within a specified time.
Lordship, may I
In
hand up a
default,
copy
Lord,
of a judgment passed by the coordinate bench where there was a direction to pay upon the state of West Bengal. There were substantial concessions given and a time was also framed by 30th of May. They were supposed to pay, they failed it. Therefore, my client, Lordship, the decree
different
holder,
fact, Lord, what my learned friend was showing, Lord, in
kindly
an
look
arbitrary.
at last paragraph of the judgment.
Completely different facts, not in this matter, not the state had
This was
paid
also in an
pursuant to order
execution
of Supreme.
proceeding.
In an arbitration matter, state had not this is not the famous, not that BBM matter, my lord, where not the state had paid pursuant to orders of Supreme Court. Not they were claiming further interest, not which the state was resisting.
Now the Supreme Court has dismissed the SLP also. This has been upheld, this judgment, Lordship. Despite directions to pay, they failed to pay in an execution proceeding. Therefore, I'm pressing my prayer A and B.
What I was suggesting, but the state not could be directed not to pay within not 6 to 8 because normally the pujas the department will be closed. So within 6 to 8 weeks, not they could be directed to pay. Not in default, the attachment order can be passed. But state will not run away anywhere. Not it's
Let
not
it
that.
be attached and direction for release may be given. And with Lordship, if my learned friend is inclined to pay directly, then that payment may be done in the meantime, Lordship. I'm pressing my prayer A and B in column 10, Lordship.
Lord, on the first day, Lord, if your Lordship desires, Lord, then attachment can be done in terms of prayer, Lord. I'll come back after vacation, Lord. If I'm ready with the payment, then this can be vacated and
Lordship, this is a suit of 1997, almost 30 years now.
The total amount?
We should 42.
42 lakhs, 26.
12 lakhs principal, 30 lakhs interest.
Lordship, the interest was directed to be paid until payment.
9%.
Yes.
And that also 9%.
My friend should be grateful to my lord, not for hearing the suit and disposing it off, not which was lying in cold stage.
This definitely was a tough battle getting the counsel for the state every time they were seeking adjournment.
No, before this court, you will get roll call.
I'm grateful to you,
Lordship.
They always it's very difficult to make a lady happy, my lord. It's irrespective of what stand I take.
Sorry, don't make that comment. The decree holder has filed the present execution proceeding to execute the judgment and decree passed by this court dated passed by this court dated 16th April 2025. Counsel for the decree holder submits that the decree was passed, judgment and the decree is passed in presence of the an advocate appearing for the defendants, and the defendants are having the knowledge about the decree, but in spite of the same till date, the judgment debtors have not paid the decretal amount along with the interest as directed by this court. Accordingly, learned counsel for the decree holder prays for attachment in terms of prayer A and B of the
attachment and release, Lordship.
Attachment is prayer A only, Lord. B is
release. I have pressed for A and B, Lordship.
Attachment and release of the amount in terms of prayer A and B of the tabular statement. Learned counsel for the decree judgment debtor submits that he may be given some time so that they can take appropriate steps for for payment of the decretal amount along with the interest as directed by the court. Considering as the judgment debtors are appearing in the matter and raise before this court that they will take appropriate steps so that the decretal amount along with the interest can be paid to the decree holder accordingly for the interest of justice as the matter is moved on the first date after filing of this execution, one opportunity is given to the judgment debtor to pay the principal amount as well as the as well as the interest as decreed by this court within by
Lordship makes it 3 weeks after vacation.
Kindly keeps it before the vacation, Lordship. Before the vacation, Lordship. Otherwise, Lordship, Lordship, this is a suit of 1997 and the contract is way before that.
A date by 29th of October 2025.
Lordship, that is after any day before the vacation, Lordship.
But again, they will take the time. You know the administration. Otherwise, I can pass. But again, they will come and because
in the case of attachment, Lordship, that is it is debited from the account line.
Okay, let the matter appear on 26th of September 20.
I'm grateful.
Let's see what
Today is not.
Today we are on 10th, 11th, 15 days.
Before.
Okay, what are the process? Please bring that whether you have process or not.
I'm grateful.
26th September 2025.
6 my lord, I'm for the defendant, my lord. This is appearing under
my lord, I beg to appear, my lord, on behalf of the plaintiff. Lordship, on the last occasion, my lord, there was a direction for inspection and discovery of the documents. My lord, the plaintiff has duly carried out the inspection, my lord, of the documents, my lord, as well as, my lord, our affidavit is ready. My learned friend, my lord, for the defendant, my lord.
But if my learned friend pleases, my lord, this was the email communication between the parties. Kindly see the second.
My lord, this was the last. My lord, this was the my lord, reminder, my lord, because we have made several email communications, my lord, on from the last 2 months, my lord.
I will kindly see the second page. It is my last mail, and after that they came to take inspection on 13th August. They have taken inspection, and in that mail I specifically said bring the documents so that I can inspect. But thereafter no communication, and suddenly yesterday at 7:55, communication was given to complete the inspection.
But whatever it is,
chance may be given.
Before August, my lord, we have.
Chance may be given to me for inspection. I have paid.
Correct. If they have completed the inspection, so you have to follow the order.
Yes, I have prayed for inspection. My lord, can you see my second page?
When you have prayed?
On 30th August.
They have asked us to bring our original documents to their office, my lord. My lord, we have requested them prior to August as well, my lord. And recently, yesterday, my lord, we have made.
The counsel for the plaintiff submit that the plaintiff has disclosed their document to the defendant for inspection, and accordingly, the defendant has carried out the inspection.
No.
Plaintiff has carried out
the documents, and they have carried out the inspection.
We have carried out the. Now, my lord, we have requested them to visit our office, my lord, to
yesterday
inspect the. No. This is wrong submission, my lord. I can show, my lord, previously.
Mail is already there. Kindly see the mail dated. That one page I have given.
Since I'm not there physically, my lord, there's a difficulty, my lord, on my part. I'll indicate as well if my lord so pleases, my lord. Otherwise, if they can carry out the inspection, my lord.
Document inspection is completed.
My document inspection has been completed.
We have taken yes, my lord. Yes, my lord. We have visited their office.
Counsel for the defendant submits that the defendant has disclosed their document to the plaintiff, and the plaintiff has completed the inspection. And document of the defendant. But why you not disclose your document to the defendant, sir?
No, my lord, there was, my lord, we have always requested, my lord, them to visit our office, my lord. Otherwise,
requested you. Where is the reply of the 13th August? 13th August, you have given the reply on 10th of September.
No, my lord, since, my lord.
The plaintiff could not, but the plaintiff has not disclosed their document to the defendant for inspection. Though the defendant has by a letter dated by an email dated 13th August 2025 requested the plaintiff to disclose their document for inspection. Considering the situation mentioned above, the plaintiff is directed to disclose their document to the plaintiff and to the defendant by 16th of September 2025. Also, the defendant is directed to complete the inspection by 22nd of September 2025. Lease the matter on 24th of September 2025 for
My
filing
lord.
affidavit of document by the parties.
Keep leverage, my lord.
My lord. Grateful.
Please, Your Lordship.
Yes.
Your Lordship, as per the last order, that is 11th of June, the defendant have still not filed their admission denial. This was firstly ordered by this bench on 9th of April to file admission denial. Till date, Your Lordship, the defendants have chosen not to. So I request Your Lordship, their right may be closed. Secondly, Your Lordship, I have filed a GA number 1 of 2025. Your Lordship, what has happened that my recovery suit is for 32 odd lakhs. In their WS, the defendants have chosen to accept a liability of 3,75,000. And in lieu of that, Your Lordship, I request that Order 12 Rule 6 may be invoked, whereby part payment admitted by the defendant may be decreed in favor of the plaintiff.
Yes. Have you served a copy of this application?
Please, Your Lordship.
Order 12 Rule 6?
Yes, Your Lordship. I had served them on 4th of July.
Where is that? Where is the affidavit of service?
Your Lordship, affidavit of service has already been filed, Your Lordship.
You have filed. Where is the acknowledgement they have you have served?
Acknowledgement is on, Your Lordship, there is a bundle of notice of motion. On the last page, Your Lordship, there's a receiving by the advocate for the defendant, Your Lordship. Ayan Kumar.
There's nothing.
Your Lordship, I have it with me. Your Lordship, if you may give a passover, I'll just ask my colleague to just inspect and just assess this bench. It is there on record, Your Lordship. We have filed it. In the admission, with the affidavit, the last page has the receiving.
Which affidavit?
Affidavit for service.
Affidavit service.
Your Lordship, we have filed an affidavit where we are acknowledging that we have filed and served the opposite counsel.
No such endorsement is here, sir.
Your Lordship, may kindly give a passover, Your Lordship. I'll just seek instruction and ask my colleague to assist.
Next.
Wait, please, Your Lordship. Yes. We are ready with the suggested issues. Your Lordship will kindly note this.
My lord, I appear for defendant number 1 and 2. May I hand over the suggested issues from our side also?
This is our suggested issues on behalf of the plaintiff.
Where is your suggested issue, sir?
My lord, it has been, I think my clerk is there. He has already handed it over.
On the 5th of May, my lord, Your Lordship was pleased to pass an order, paragraph 8, my lord, where this direction was given for framing of issues on 8th of May, my lord.
Yes.
My lord, the affidavit of admission and denial of documents are also ready, my lord. Kindly grant us some time because, my lord, by the next day we'll file it, my lord. It's not affirmed yet. Discovery and inspection is complete.
Which issue is with whom? Both has stated that the suggested is of whom?
There's a
My lord, the back sheet, my lord, suggests, my lord, for the defendants we have filed.
Suggest. Who is appearing for the defendant?
My lord, defendant number 1 and 2 I appear. 3 and 4 I don't know who is appearing.
My learned friend is appearing. He's instructed by Morgan.
Yes. What is the suit for?
It's a simplicity case where, my lord, we had some shares. We wanted the defendants to sell it. They were not selling it. In the meantime, my lord, the quantification of the shares come down. We have claimed damages, my lord. That's the essence of the matter. We have made repeated requests that please sell off these shares. By then, my lord, the market value of the shares fell and, my lord, we suffered damages. That's what we are claiming in the proceeding, my lord.
My lord, on that quantification, my lord, we have filed our written statement also. We are relying on some market regulation notifications. That's very primary for proving our case. That's one of the issues, my lord, in the.
That we oppose, my lord, because that. And they have not served. Have they given a copy of the?
That's the part of the affidavit documents we have already given inspection.
The affidavit of documents have not been served on us. So I think my learned friend has to.
No, it has already been served. It has already been served on 6th of May.
Why?
Someone named B. Pal from their side has already accepted it.
That's our advocate on record, my lord, Mr. Balaram Patru, but I'm
Yes.
sure it has not been served in accordance with the commercial division rules of the court, my lord.
Bank guarantee also.
My lord. The fifth issue, my lord. Security deposit as well as a bank guarantee.
Both have been revoked.
My lord. We say it's wrongful invocation, my lord, so that's also an issue which we have framed.
They are having the counter claim. They are having the counter claim.
Yes, my lord. We are having a counterclaim.
Because your suggested issues, page number 5, last one, whether the plaintiff is liable to pay the defend number 1 and 2.
My lord, the last one.
So,
Yeah.
देखो
13 lakhs.
counter claim है क्या? Return statement counter claim है.
They have, my lord, a counterclaim. Paras 9 and 46, my lord.
So your last issue,
my lord,
is overlapping the issue of first issue of the defendant because they are counterclaim the claim.
They counterclaim that they have, my lord. We actually do not have, my lord, the suggested issues filed by them because that's the prayer at page 15 of their written statement, my lord, along with the counterclaim.
And counsel for both the parties have filed their suggested issues at the learned counsel for the respective parties. Peruse the pleadings and the suggested issues. The following issues have been framed. This. Yeah, no. So I am deleting your last one. So
Yes,
because
my
they are
lord, because that's
contract claim
overlapping,
is-
my lord.
ये नहीं आएगा. And you have with regard to the issue number 2 and issue number 6.
My lord.
When they are overlapping, so I am taking the issue number 6. I am not taking the issue number 2. Maintainability in law on the basis of the pleaded in the pleadings. Because 2 you have taken the claims of the plaintiff are tenable due to the technicalities in connection with the trading. So claim of the plaintiff is maintainable in law on the basis of facts pleaded in the pleading. So that will come.
Very well, very well. That it actually covers, my lord. Yes.
That covers.
Yes, my lord.
ये नहीं आएगा. प्लेंटिफ का ये आला नहीं आएगा. बाकी सब आएगा. डिफेंडेंट का ये आला नहीं आएगा. बाकी सब.
Very deep privilege.
Grateful, Lordships.
So judge will document. Affidavit of documents filed.
That's kindly granted, sir.
My lord, actually what happened, my lord, I just came to know the affidavit of documents were given, but that was not as per the commercial rules. My lord, I'll make sure, my lord, it goes, my lord, within
Both the parties
next week.
directed to file the affidavit of documents within 2 weeks from date. Full stop. The plaintiff. So you would also file the judge's bill of document. I just
But
contacted-
I'll just hand it over to them. They are plaintiff. They can file the judge's before documents.
Judge's bill of document because you are also having the counter claim.
Very well, I'll prepare them.
Both the parties are directed to file their judge's bill affidavit document within 2 weeks, as well as the judge within 2 weeks. The parties are also directed to file their judge's bill of document within 3 weeks. Full stop. Within 3 weeks. So you will adduce evidence.
We will.
Full stop. Let them give the date for witness action. Let the matter appear on 1st December 3 p.m. No, full stop. Get it there. The plaintiff is also directed to file the affidavit of evidence. Evidence after serving the copy to the learned counsel for the defendant. List the matter on 1st December at 3 p.m. for witness action.
I'm very deeply obliged.
I'm grateful, Lordship.
Next.
Lord, I appear for the plaintiff.
Defendant
Lord,
7.
I'm
Your
sorry.
the
Defendant number-
suit is appearing at my instance.
I'm
Your
sorry, Lord, defendant number 7.
Your Lordship, during the pendency of this suit, Your Lordship, one appeal was preferred. Thereafter, Your Lordship, upon the suggestion of the Honorable Appeal Court, both the parties went for the settlement, Your Lordship. Now, Your Lordship, that settlement has failed. Your Lordship, we are willing to proceed with the suit. Your Lordship kindly keeps it after vacation.
What has happened to the
No, my
appeal?
Lord, the suggested issues are there. We have drafted the suggested issues. My Lord, Lordship can frame the
Is there,
issues. We are
Your
willing
Lordship?
to
I am
proceed with
only
the-
praying, Your Lordship kindly fixes a date after vacation.
What
We
has
shall find.
happened to the appeal?
Your Lordship,
The appeal is pending, my Lord. Appeal is pending, my Lord. That was on the point of, my Lord, Order 7, Rule 11 and 39, 1 and 2. Two appeals, my Lord, they are pending. My Lord, it has got nothing to do with the suit. We are ready to proceed with the suit, my Lord. We have prepared the suggested issues. Your Lordship may please to fix it for the purpose of, my Lord, filing of judge's brief of documents and, my Lord, witness action.
Where is the suggested issue?
Your Lordship, I shall file it
You are
after
for the-
vacation. I am for the plaintiff, Your Lordship. Your Lordship kindly fixes a date after vacation, Lordship. I shall file.
After vacation, sorry.
Your
Suggested
Lordship, then,
issues.
Lordship, Your Lordship then kindly grants me a 2 weeks time, Your Lordship. I shall file it before Your Lordship.
On
But
the
2
last
weeks takes us to the vacations.
Yes, on the last
Your
occasion, you
Lordship,
take
settlement has failed few weeks
Settlement has
back,
failed
Your
long
Lordship.
back.
Your Lordship, I shall file my suggested issues. I am praying for a week or 2 weeks time, Your Lordship. I shall file it before Your Lordship.
Who is for the other? Who is for the other defendants?
Your
The
Lordship,
defendant had not appeared earlier.
No, Your
It's
Lordship,
principally defend number 7, my Lord. It's principally defend number 7. We are the bank, my Lord. We are out of pocket.
Defendant number 7 has filed the suggested issues. Let the same be kept with the record. counsel for the plaintiff press for a week time to file suggested issues. Let the suggested issue be filed on 22nd of February, September 2025. List the matter on 23rd of September 2025 for framing of issues.
Grateful, my lord.
Grateful, my lord.
Number 10.
And your lordship, I appear on behalf of the plaintiffs. Your lordship, if your lordship takes up your lordship's last order.
The IPF for the defendant numbers 14 and 15.
Your lordship dated 12th of June 2025, your lordship had allowed the defendant number 7 to disclose further documents. Because your lordship, it was in the custody of CBI, so that your lordship, may I file my affidavit of admission and denial to the additional documents disclosed by the defendant number 7.
That has been done. CBI given the copy.
Well, time for the defendant number 7, well, the inspection has been done, well, the additional has
Admission
not
and
been,
denial.
admission and denial has not been served upon me.
I'll give a
The
copy,
original has been served upon me, my lord.
So,
My lord,
issues.
issues.
What about your affidavit of document?
My lord, I have already served
Already
upon-
filed.
Yes, sir.
Lordship, just before your lordship proceeds with the issues, your lordship, may I submit a report of the department? And if your lordship also in tandem takes up your lordship's order dated 18th of January 2024.
January 2024.
18th of January 2024, your lordship.
Yes.
Your lordship will kindly take up page 2, second paragraph. Your lordship was pleased to make the suit undefendant against the defendant numbers
3, 4, 5, 6, 9,
9 to 13 and 16. Lordship, the defendant number 7, if your lordship takes up the report, though has entered appearance but has not filed his written statement. So I was humbly praying that the suit be made ex parte as against the defendant number 7 as well, your lordship.
Defendant number
Eight.
One is here.
8. I stand corrected, your lordship. 8.
8. Yes, 9 to 13.
Your lordship, defendant number 8 has not been made ex parte.
Acha, 8.
8. Because he has entered appearance but not filed written statement.
The defendant has entered appearance on 10th of September 15.
But
Yes.
no written statement filed, so if your lordship makes it ex parte as against the defendant number 8 as well.
And
Your
what
lordship,
about the suggested issues?
lordship, suggested issues.
I have already served them a copy, my lord, long back.
Lordship, I have
Ready, my lord, but
Lordship, I am also carrying the suggested issues. Your Lordship, we had probably filed the suggested issues before as well. But in any event, Your Lordship, I am carrying a photocopy as well.
Suggest है. What is the suit for?
Lordship, suit for declaration. Lordship, the modus operandi was such that the plaintiff had
retained the 3 crore rupees paid by the defendant.
Lordship. Because I'll tell your Lordship, the case here is a peculiar one. I had made an FD. Though it turned out later on that and I had signed documents to that effect, but later on it turned out that the defendants in connivance with each other had made that, instead of investing it in the FD, they had made it a current account. Thereafter, Your Lordship, I received notices. I file a case as well. Thereafter, Your Lordship, they refund me the amount. So I'm seeking, Your Lordship, the declaration that these are not proceeds of crime because the other defendants have been roped in some bigger scam.
So your issue number 2 and 5. Defendant number 1 acted fraudulently, negligently in violation of the applicable upon being informed regarding the fraud perpetrated upon son. Item number 2 again. Issue number 2 and 5, read it.
Yes, Your Lordship, it's in RBI circulars.
Based on the forged document without verifying the document.
Lordship, that can be clubbed into one.
So I am not taking 5.
Very well, Lordship.
May I interrupt, my lord? I apologize, my lord.
Why the jurisdiction point you have taken 2?
Yes, my lord.
Whether this Honorable Court has jurisdiction to grant decree for declaration as per prayer clause A of the plaint, since the sum of rupees has been seized by the CBI as proceeds of the crime and criminal is pending before the designated. So it is your defense. So why the jurisdictional issue? If you prove that you could not pay the amount due to the seizure of fees by the bank, that is your defense. And that cannot be a issue, madam.
That's on the merits.
Correct.
Sir.
And what about the 5? Whether the plaintiff come to this honorable court with the clean hands and the suit transactions pursued dubious and fraudulent in the nature as per averment made in the plaint, the contended as contended by the
But there are some preliminary if your lordships ignore.
and preliminary objection of its written statement and official,
But
what it can be.
can it not ignored, my lord?
So it will be recasted whether the plaintiff has committed any fraud upon
Yes,
the
my lord.
defendant. That's
That will be enough, my lord.
Very well.
Both the parties have filed their suggested issues. Plaintiff has filed the defendant number 7 has filed the affidavit document, affidavit of admission and denial of the document. Let the same be kept with the record. Heard the learned counsel for the respective parties, perused the pleadings and the suggested issues. The following issues are framed. 1, 2, 3, 4, ये नहीं आएगा, ये 5, 6, ठीक है, ये 11, ये नहीं आएगा, ये 12, इस जगह में 14 नंबर इशू लिखो. Whether the plaintiff has committed any fraud upon the defendant number 7. Defendant number 7. Number or लिखो. Whether the plaintiff is entitled to get any relief as prayed for by the plaintiff. ठीक है. Judges brief filed.
No, Your Lordship, we will file it.
Counsel for the plaintiff has drawn the attention of this court to the order dated
18 January
2024, wherein this court has place the matter as undefended suit against the defendant number 1, 2, 3, 4, 5, 6, 9 to 13 and 16. Counsel for the plaintiff has handed over a service report issued by the Deputy Registrar within bracket legal dated 22nd of July 2025, wherein he has pointed out that the defendant number 8 has entered appearance in the suit on 10th of September 2015, but till date has not filed the written statement, and nobody is representing the and none represents defendant number 8 in the suit. He prays for proceeding the matter against the defendant. He prays for fixing the matter as undefended suit against the defendant number 8 also. In view of the submission made by the counsel for the plaintiff, this should be placed in the list of undefended against the defendant number 8. Grateful. The report be kept to the record. How much time? The judge's brief of document?
Lordship keeps it after vacation, we will file it.
The plaintiff is directed to file the judge's brief of document after serving the copy to the learned counsel for the defendant within 2 weeks after Puja vacation. Full stop. The plaintiff is also directed to file the affidavit of evidence within 2 weeks thereafter. This is the matter. Give the date.
Your Lordship is fixing a time. Lordship, may I only humbly submit this? Let me file my affidavit of evidence, then your Lordship gives a time.
Why?
Your Lordship, otherwise, if I'm out of time, your Lordship will fix the matter, and if I have to, it will be embarrassing on my part to ask for any.
4 weeks, 2 weeks have given.
Very well, Lordship.
December,
I do not want to embarrass myself by asking
December.
Very well, Lordship.
8th December. 8th December at 2 p.m. At 2 p.m. Because otherwise the procedure will be
very well, Lordship.
As per the Commercial Court Act. 8 December at 2 p.m. for witness action.
Grateful, Lordship.
Next.
My Lord, I'm appealing for the plaintiff.
Yes.
My Lord, we have prepared the affidavit of admission and denials and served it on the other side. My Lord, and I've also come with the suggested issues, my Lord. My Lord, your Lordship may please to have a look at the suggested issues.
The defendant, on the last occasion, your Lordship had extended time for giving inspection. The inspection has been given, I believe, but I am requesting for an accommodation because my advocate on record has not been able to contact the guy. Some personal difficulty for the defendant number 1. We'll be preferring an application and filing before we can frame the issue. Kindly gives us some time.
Inspection completed.
We have yes, my Lord.
I believe, and they have given the admission. Lordship will, before your Lordship picks the date.
What about your admission and denial? Defendant's admission and denial?
That is what I am submitting. There's some excellencies with the advocate on record. He has not been able
to. I find from the record this framing of issues has kept pending for the last several months.
I bow down to what your Lordship is saying. I acknowledge it.
That's why I fixed the in the upper side, but you all persons are not ready with how the suit can be proceeded.
I tender my deepest apologies, your Lordship. But
yes, what about you? Defendant number 1?
They have no claim against me at all, practically. I am for the port trust, my Lord. He is my tenant. So his claim, plaintiff's.
So you are not having any document?
Any document.
So how much time?
I have 2 weeks time, your Lordship.
2 weeks?
Yes, your Lordship. You can record my submission.
Plaintiff has filed affidavit of document affidavit admission and denial of the document. Let the same be kept with the record. Counsel for the defendant number 1 submits that there is no claim against the defendant number 1, and as such they are not relying upon any document. Counsel for the defendant number 2 prays for 2 weeks time to file affidavit of documents.
I am for the defendant number 2, my Lord.
Defendant number 1. Defendant number 2. You are appearing 2. 2. Abhi likha na? Abhi. Defendant number 1 has pressed for time to file affidavit of admission and denial of document. And what about the suggested issues? Same.
Well, I have come with it, my Lord. I have handed over to your Lordship's officer.
Lordship can also record that I am filing an application.
Plaintiff has also filed suggested issues. Let the same be kept with the record. In view of the submission made by the counsel for the defendant number 1, case is adjourned. Let the matter appear on 25th of September 2025 under the heading Framing of Issues. In the meantime, the defendant number 1 is directed to file the affidavit of admission in the document and to exchange the suggested issues.
Finally, we'll keep it on the first week of reopening, first day of reopening. First day of reopening, Your Lordship.
28 October. Girl.
Grateful. Okay.
Grateful, my lord.
Next.
My lord, am I
Calling.
audible, my lord? My
Yes.
lord, I'm appearing for the plaintiff, your lordship. My lord, at the first place, I apologize, your lordship. My lord, I'll be seeking some time to file my affidavit of admission and denial, your lordship, my lord. If my lord kindly grants me some time, your lordship.
So far, my part is concerned, my lord. I have done the affidavit of admission. I have served the copy
My
as well.
lord, yesterday, my lord, only yesterday evening, my lord, we have received the affidavit of admission and denial from the defendant. My lord, I'll be filing mine, my lord. I have taken instruction.
And what
My
about
lord,
the
kindly grant me.
issues?
My lord, on the next date, my lord, we will definitely, my lord, file the suggested issues as well. My lord.
Mr. Burman,
My lord.
have you filed the suggested issue?
Today, I'm not bringing, my lord. On the next occasion, I'll bring.
Counsel for the plaintiff prays for time to file admission, affidavit of admission, denial of the document, and suggested issues. Defendant has filed the admission and affidavit of admission denial the document. Let the same be kept with the record. The counsel for the defendant also prayed for time to file suggested issues. Considering the submission made by the counsel for the parties, the plaintiff is yes before vacation you can do.
My lord, if my lord kindly keeps it after vacation, my lord.
The plaintiff is directed to file the affidavit of admission and denial the document by 4th of November, as well as suggested issues by 4th of November 2025. The defendant is also directed to exchange the suggested issue by 4th November 2025. List the matter on 7th of November 2025 for framing of issues.
Grateful.
Lord, I beg my lord's leave to appear online. I am for defendant number 3 in item number 30.
Lord, I am for the defendant number 1 and 2. Lord, though the matter is appearing under the heading of framing of issues, Lord, we have completed our inspection and discovery so far as defendant number 1 and 2 is concerned, and we are also ready with the affidavit of admission and denial. However, Lord, in the meantime, Lord, I have filed an application for amendment of my written statement. I'm not in that matter, Lord. I'm also led by Mr. Jayanta Mitra, Lord, senior advocate, who is not in town today, Lord. In any event, Lord, this application is required to be heard on affidavit.
What application?
Lord, application for amendment of written statement.
I'll tell you, Lord.
And also for bringing on us further document on record.
This is a suit for recovery of money where your lordship was pleased to pass a decree for an admitted sum. That decree has been affirmed by the appellate court. Now, after that, execution was the decree was put into execution, and they have paid that money.
Their thirst has been satisfied to that.
But with regard to the rest of the claims in the suit, they have now come up after beyond 1 year and above. They have come up with the application for amendment of the written statement and also want to disclose additional documents. But this being a commercial suit, but I really need to argue before your lordship that this is not maintainable.
Let the point of maintainability be kept open and let them come up with the affidavit, my lord. And may I file my admission and denial? Affidavit of admission. I have served them.
You are appearing for defendant number
1 and 2.
What about the 3?
3, my lord, he is
Lordship, I am appearing for defendant number 3.
Yes.
I also filed the affidavit of admission and denial.
But what about your admission and denial of the document?
Lordship, it's ready, it's yet to be signed.
So, can I send it to your home?
Lordship, I will be filing the same before the this court next.
So, GA है क्या?
Yes, my lord.
GA 10, my lord.
So you will
What-
file
I would file an affidavit. Kindly keeps the point of maintainability of this application.
Then counsel for the plaintiff and the defendant number 1 and 2 have filed their affidavit of admission and denial of the documents. Let the same be kept with the record. ये किसका है? ये कौन दिया? Who has filed that?
But for the plaintiff.
Plaintiff affidavit and did not.
There are two, my lord.
There
For
are
two
two
different
sets of
documents. For two different.
File the affidavit of admission and denial of documents. Let the same be. Counsel for the defendant number 3. Praise for time to file affidavit of admission and denial of the documents. Full stop. The parties are also praised for time to file suggested issues. Full stop. The counsel for the defendant number 2 submits that the defendant number 2 has filed an interlocutory application being GA10.
Yes, blood.
Of 2020?
2025.
2025, praying for amendment in the written statement as well as for disclosure of additional document. Full stop. Counsel for the plaintiff raised the maintenance of the said application. Full stop. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition in connection with GA10 of 2020 filed within 3 weeks.
3 weeks.
Before vacation.
But
within 2 weeks after vacation. Reply, if any, there to be filed within a week thereafter. Full stop. The majority of the application is kept open. In the meantime, the parties are also directed to, and the defendant number 3 is directed to file the affidavit of documents within 2 weeks. And the parties are also directed to exchange their suggested issues. List the matter on 3 weeks bola na? 2 weeks and 3 weeks. List the matter on 25th of November 2020.
But instead of 25th, can it be 26th? Only 26th.
26th of November.
Either before
26.
Deeply okay.
Yeah.
পরেরটা দেখে নেন পরেরটা কেউ নেই না পরেরটা আমাদের পরেরটা দেখে নেবেন
I am for the plaintiff, my lord. The witness action had.
It is fixed today for argument.
The witness action had completed.
Today is fixed for argument at 2 p.m. but my 2 p.m. is appellate side. So I am fixing another date.
Yes.
No, I am fixing tomorrow. No, today at 3:30. You're not hearing what the court is telling. You're not reading the mind of the court. Yes. Yes, what is the submission? Granted. Yes.
Not any day, but
Joseph করে দেবেন সব
By an order dated 25th of July 2025, the matter is fixed today at 2 p.m. for argument, but due to the determination of the appellate side matter, the matter could not be placed in the list at 2 p.m. for argument. Accordingly, the hearing of the case is refixed on
whenever not does.
December. दो डेट दे दो आर्ग्यूमेंट है
December.
Number का. Yes, December 2 dates I am giving so that matter can.
Yes, they are in argument. If
8th and 9th.
8 and 9 at 3 p.m.
8th and 9th.
8th December, 9th December at 3 p.m. For argument.
Oblige.
Next.
Oblige, my lord.
Number 2, my lord, I have for the defendant, my lord. This matter also, my lord, declares the date be fixed, my lord.
Lordship, this was only for the concluding submissions.
Correct. But
we were to give reply. We were to give reply, my lord, on the judgment cited by my learned friends.
Though by an order dated 2nd September 2025, the matter is fixed today at 3:45 p.m. But due to the determination of the appellate side matter, the matter could not be taken up for hearing at 3:45 p.m. Accordingly, case is adjourned. Let the matter appear on. वो बहुत लंबा है, इससे तो खत्म होने वाला है। ये इसमें कहीं है 3:45 ये बीच में सितंबर में कहीं है?
So next Friday will be convenient to your lordship, my lord.
Next Friday date का प्रोसेस
यार रीओपनिंग में नहीं है, रीओपनिंग में देखो नहीं होगा तो फिर
फ्राइडे
29 अक्टूबर कितना बजे? 3:40 29 अक्टूबर 3:45. Yes, next.
My lord, before my learned friends start, my lord, may I make a very small submission, my lord. My lord, these are three, my lord, originating summons suit, my lord, what I have understood. My lord, this was first filed before the Court of Justice Orindo Mukherjee, who has released the matter. My lord, I had appeared before Justice Mukherjee, my lord. I had sought for a copy of the, my lord, this originating summons, if I may say so, my lord. My lord, it was not served. Before your lordship, my lord, when it was mentioned, I also came back and mentioned to change the date, my lord. I have made repeated attempts to get the copy, my lord, but I have not been served subject to correction, my lord. So only submitting, my lord, in an originating suit, my lord, without a service on the other side, if I may say so, my lord, because in originating suits, my lord, there is really no other side. It's an advisory jurisdiction, my lord. So, my lord, they should at least serve us first. Second, my lord, on a similar prayer, on a similar originating summons, my lord, your lordship had passed an order. My lord, I'm without any
demurrer. That is not a point of demurrer. That's
please,
a
please,
allow me.
Mr. Ghosh, yes. Yes,
my
continue.
lord, my lord, an order was passed by, my lord, I'm not on a demurrer or anything of that, so I'm just pointing it out. My lord, an order was passed by your lordship, my lord. But with humility and, my lord, kindly do not take me amiss, my lord. But an appeal was preferred and the appeal has been heard out and it's marked for awaiting verdict. My lord, yesterday it was heard out. So, my lord, yesterday it was heard out and it has been marked as CAV, my lord. I now leave it on your lordship. Your lordship is taking it up, and I will obviously not stand in your lordship's way. But only, my lord, they should at least serve us a copy. My lord, under the originating summons rules, my lord, with humility, I say, my lord, the rule is that first, my lord, the summons has to be served on us, on the other side. It is only thereafter, my lord, when your lordship's in
So
form
what is the hearing fixed today?
My lord, it's the first time.
My lord, let me go stepwise. Matter was fixed. Mr. Ray came and mentioned the matter, saying that he has some difficulty, and I immediately agreed. That was done. Now it transpires to move the appeal. Anyway, we are not on that.
No.
Today, my lord, the matter is fixed. My lord, a plaint, the originating summons suit as it stands today is the plaint. My lord, no defendant has the right to be served with a plaint before I present the plaint or move it. There is no right. Today, my lord, the suit is being heard out for the first time before your lordship. I am moving the suit for the first time. It's for your lordship to, my lord, consider what my reliefs are in the originating summons, what are my prayers, and thereafter, if your lordship feels that they need to be served or an interim order protection is to be given and then they need to be served, is up to your lordship. I will abide by whatever your lordship says. But saying that even before I can move my plaint, a defendant has a vested right to have a copy of the plaint, my lord, is not something that, my lord,
My lord, then may I take this as a point of demurrer and show your lordship the original side rules, my lord? If your lordship permits me that, my lord.
Kindly allow me to move the plaint. Let us see.
My lord, there is no scope of moving the plaint before service, my lord. With humility, I say that's the original side rules, my lord.
Suit. My lord, your lordship has already dealt with it.
So what,
My lord,
the suit is to be first admitted?
Yes, my lord.
My lord, there is no scope, my lord, in the original side rules, chapter 13. My lord, kindly have a look, my lord.
When you file the suit?
My lord, I filed the suit, my lord, sometime in, my lord,
August, 7th August.
7th of somewhere maybe a little 11th August, my lord, a few days thereafter. This was affirmed on 7th. I filed it on 11th.
So this is the first time.
Yes, and my lord, it was supposed to come up number of times. Sometimes it was, my lord, Friday was, my lord, declared holiday.
Okay,
Or
in that case, Mr. Ghosh,
yes,
now the defendant intend to appear. Let the notice be issued. Let they appear, and I am dispensing with the notice.
yes, my lord, but my lord, I also have some interim orders which I am
Okay,
pressing for.
okay, I will take. Let the notice be issued and let.
I can serve a copy of the plaint, but in the meantime, today, if the property, my apprehension is that they are going to sell the property over the weekend.
What interim order you have prayed?
Yes, kindly, my lord, takes, my lord, kindly allow my lord senior, no, kindly takes, allow me to file the supplementary affidavit, my lord. Kindly, my lord,
Audience group sir.
my lord, kindly takes the supplementary affidavit with the leave of my learned senior. My lord, kindly see page 6.
Plaint supplementary affidavit.
Page 6. It's a peculiar nature. Everything.
Supplementary affidavit in a plaint.
Supplementary affidavit
in a plaint.
My lord, kindly see.
My lord, Mr. Ghosh is. My lord, this your lordship kindly see the rules first, my lord. That is why I'm saying, my lord, it's very important.
It is of peculiar nature. Every judgment has held that. My lord, page 6, kindly see. Shamin@gmail. One of the employees of, my lord, the trust writing to another employee of the company. Kindly see, Mr. Jha, following our discussion and to move forward, we require a detailed property and title synopsis for the Jerambai Hospital property. Additionally, the proposed buyer wishes to convene a meeting at your office to review the property information and submit their offer. They are looking to schedule this meeting for a date of post July 14, 2025. Post meeting, they would be visiting the property for inspection. This is a property of the trust, which is now being sought to be sold, and proposed buyers are moving. My lord, kindly see the date, 4th of July. Kindly turns to page 7. This is a. I'm sorry, my lord. Page 7.
Yes.
Yes, page 7. My lord, 6th of September 2025, a demand draft is being issued to themselves of 2,33,99,000 from the Seva Trust. Why? Because they will settle, kindly come to the next page, they will settle with all the tenants so that the property is, my lord, made absolutely ready for sale. Page 8.
So who are you? Who are you?
My lord, kindly allow my.
I'm the beneficiary of the trust.
Subsequent fact,
Millard, the reason why it has come by way of a supplementary is this, Millard. We have the suit, as my learned friend told your lordship, Millard, was filed in August, and we have come to know of this very recently. Oh,
supplementary if it in a plaint, I have not heard this.
Yes.
Now, Millard, if your lordship has seen the deed of trust, Millard, your lordship will find that
so
it
you
is
do one thing, whatever that they are appearing, you are appearing for all.
Millard, all.
Yes, my lord, I'm appearing for all, my lord.
A copy be served to them.
Yes.
Let the copy served to them. I am fixing a matter.
Yes, but Millard,
with the
let
leave of
them. I don't want an order from your lordship. Let them assure that the properties of the
Millard,
trust
with
won't
leave
be
of
dead.
Mr. Ray, Millard, we had entered appearance before Justice Mukherjee since 14th of August. We have been writing them every day that serve as a copy. Millard,
Mr. Dasgupta.
it would have been done this, Millard, today only.
Okay,
Millard, take everything. I am a bad man. I am a watched man. I am evil. There is a trust deed. Both parties agree.
Malad, this is not a section 92 trust,
let
not
me
a 92 action, Malad. Kindly, Malad, now since they have completed, Malad, let us see the original side rules, Malad, for once.
Very well.
This has been completely, every instance, Malad, your lordship has been told that it can be moved like this, Malad. Can I just show your lordship, Malad? Kindly with your lordship's indulgence, Malad.
Yes. Very well. Let him show.
Malad, kindly sees.
Millard, chapter 13.
Which rule? Which rule
chapter
you want?
13? Chapter 13.
Chapter 13, let my learned friend show that there is a bar
Yes,
in
Malad.
passing an order.
And first, I do not know what is. Your lordship will first check, Malad. I don't know, but your lordship will first check the summons, Malad. Whether it is in the form number 1, appendix D, Malad. Because I have not yet seen the copy, Malad. So your lordship, Malad, the summons has to be in that form. That is given by the original side rules, Malad. Then Malad will kindly come to rule 10 of the original side rules, Malad.
Any chapter form 1. Collage. Malad is readily open, form 1.
First is form 1, kindly, Malad, if your lordship kindly.
Yes.
But has seen Form 1.
Correct.
Mr. Dasgupta is in a better position to show whether the form is in originating summons is in
Yes,
that form.
given. I've handed over. Yes.
Malat, the appendix requires Malat that 8 days notice for appearance must be given.
Correct.
In the originating summons.
Correct.
But I don't know whether it is there in this or not. I'm not too aware of the originating summons. Kindly has a look into it, Malat. Mr. Dasgupta has already seen it. I think he has seen the originating summons as what it is to the plaintiff, Malat.
I'm not seeing. Yes. Summons
They have not served because in the earlier suit, Malat, the summons did not say this. It was not in Form D.
Yeah.
Form 1 of Annexure D, Malat. So your Lordship will first kindly have a look whether it's an originating summons. Whether they have taken out an originating summons.
Yes, then?
Then Malat kindly comes to Malat 11.
Yes.
The summons under either of the rules 8 or 9, Malat, shall be served upon the persons who would be proper defendants under the existing practice in the same relief as sought in a suit. Then Malat kindly sees 13. An originating summons shall be in form number 1 and shall specify the relief sought. The person entitled to apply shall present with it to the registrar or master an affidavit setting forth concisely the facts upon which the relief sought by the summons is founded. And the registrar or master, were satisfied summons and affidavits are in compliance with this chapter, shall sign the summons and cause it to be sealed. No original document save with the permission of the registrar or master shall be annexed to the affidavit, but copies of documents shall be annexed to the same. Then OS how to be marked? Malat kindly takes 15 now. The summons, together with a copy of the affidavit, shall be served by the advocate acting on the original side, taking out the same, and the summons after service shall be filed in the proceedings together with an affidavit of service. Then, Malat, returnable date of originating summons. Originating summons shall in ordinary case be made returnable in 8 days after service. Malat, it is in tandem with the form number 1, Malat. 8 days after service, but the judge before whom the summons is returnable may fix such longer period as to him may seem proper. No written statement or affidavit shall in the first instance be made in answer to the affidavit. So, Malat, this is the difference now. But from a regular summons with this, Malat. Now, kindly see entry of appearance. A party served with an originating summons shall, before he is heard, enter appearance by filing with the proper office in the office of the registrar on or before such and such date, dated the day of its delivery, or stating that the party defends in person, containing his name and everything. Now, Malat 16B. Where an appearance has been entered. So, Malat, first entry of the appearance. Where an appearance has been entered by any party to an originating summons, the day and hour for attendance thereunder shall be ascertained from the judge through his office and notice thereof in form number 2. Now, kindly see, form number 2 gives a form where, Malat, it is informed to the parties that on this day the hearing will be taking place. So, Malat, before form 2, Malat, it has to come before your Lordship. Your Lordship will decide a date and fix a date. Then, Malat, kindly sees 17, Malat.
Yes.
On the hearing, Malat, this is the hearing of 16B, Malat, your Lordship appreciates. On the hearing of the summons, where the parties thereto do not agree to the correctness of the facts set forth in the affidavit. So first, Malat, your Lordship will have to ascertain whether both the parties are ad idem on the facts which has been mentioned in the affidavit in support of the originating summons. It is then only, Malat, the judge may order the summons to be supported by such evidence as he may think necessary. I mean, give such direction as you may think just for the trial of any questions arising there.
Yes.
So with humility, my first submission is, Malat, your Lordship will find And obviously, what may be done on hearing, that is all there. And also, will kindly see there's a very strange nature of this rules, kindly takes rule 20, I'm sorry, I'm stretching it a bit, but kindly takes order 20 as a rule 20.
Yes.
Where the judge is of the opinion that the matter is fit to be dealt with in an originating summons. So first, this has to be opined by your lordship. He may pronounce a judgment as the nature of the case shall require. And any order made by him, whichever order is passed by your lordship, that will be treated as a decree. So, interim injunctions, whatever order your lordship will pass, will become a decree under this rule. So, the entire way in the originating summons rules have been set forth, is that first summons to be taken out, 8 days appearance for entering appearance. Then your lordship will fix a date.
So as per the rule, as per order rule 20, rule 20 is your contention is that every order is a judgment.
That is what rule 20 says.
No, kindly read.
Yes, my lord. He may pronounce such judgment as the nature of the case shall require.
Judgment, not each order
after,
shall be
after that, kindly reads thereafter.
Yes.
And any order made by him shall be drawn up by the registrar as a decree of the court.
Correct.
So, my lord, it encompasses everything. So, my lord, I'm not on that. My lord, first submission is, my lord, first things first, originating summons has to be in the form. Your lordship, I'll beseech your lordship to check whether it is in form number 1. Second, my lord, is it is only after I am served and appearance is entered, your lordship will fix a date under form number 2. And then, my lord, it is to be ascertained whether both the parties are arrived on the facts. That is rule 17, my lord. Because, my lord, I'll point out, my lord, this is a procedure where, my lord, questions and opinions of a lordship's courts are required. Now, when the question of disputed facts come in, my lord, there, my lord, your lordships, I have shown your lordship the judgment also, my lord, it is relegated to a regular suit. Because your lordships are not required to take up, my lord, disputed questions here. As a matter of fact, the judgment which your lordship... Sorry.
What you are making a submission before this court, that is on your apprehension. Here the suit still has not been admitted, no order of notice has been issued. What the procedure you have shown, that is, if this court has passed an order admitting the suit, issue the notice. If the notice is not issued under the form 1 and form 2 and all these things, then all the procedure will come. Let the court
with humility, one submission.
Court first see whether there is a notice under 2, notice under 1, and notice. Unless and until court is satisfied that yes, this is to be admitted and the notice is to be issued, then only the question of all the rules will come. And if they have not taken the notice in terms of form 2, then you can raise an objection. The notice which has been issued not in terms of the form 2.
With humility, only one sentence, if your lordship allows me, the procedure which is in set forth with humility, I say, kindly reads, rule 16, it does not say that it has to be admitted before your lordship's court, It goes through the master, the summons is served, then, it comes to your lordships. So today, that is not the procedure which is followed. It is coming up before your lordship. Your lordship is going to pass a direction, with humility, kindly does it to me, is going to pass a direction for service. But that is not the procedure. The procedure is, the service will be done once the master...
Where is the bar? The court cannot issue no notice?
I'm not saying that the court can... I'm not saying the court cannot issue the notice.
All you person go to the master and first get it admitted.
No, I'm the first person who has...
Show me the law or any of the judgment of the court. So, yes, this court is not having authority to admit and issue the notice.
I'm not saying that,
without the master. Now the matter has come before this court. Court has to examine whether the originating summons suit is to be admitted or even not admitted, whether the notice is to be issued or not. What your procedure?
I am not in... No.
The procedure has been prescribed.
I am not standing in the way. But I'm definitely not standing in the way.
That's why the first question this court has put to Mr. Ghosh, whether this a first move or the second move. Is the first move. Is the first move, the court has to see.
Then may may I just say one more thing, Malad,
That's
and
when the
I'll
first
rest,
when you
Malad.
are appearing before this court, if you are ready to accept, I am passing an order. Let you receive the notice, and I will fix a date for hearing. No problem. If you have no instruction, you will not appear, then I will pass an order to let the notice be issued. Then they will take it.
Malad, I have been asking for this from them continuously. From Justice Mukherjee's bench, I have been asking.
What has asked for?
I've given letters, Malad.
Whatever it is now before the
I've
court.
given letters.
If you want the
Malad, if your lordship,
you want that you will appear in the matter, the notice is to be dispensed with.
I will.
Then I will pass an order.
I will, Malad.
And you come now.
Let it be issued.
As per the diary, I will fix the date and I will let
Yes, yes, Malad. I am not standing in the way. But, Malad,
I
Malad only
never obtain an order or intend to obtain an order behind their back. But Milord, your lordship's diary will take us. Milord, your lordship, in the urgency, Milord, those 3 letters are there. This is a trust. Milord, if it can be taken.
Malad, if your lordship is minded, I am ready for Malad, Monday your lordship takes it up. If your lordship diary.
That's Mr. Ray. I appreciate the procedure you rightly pointed out. But that procedure is only once the court has issued the notice. Okay, they have not gone to the master, but they came to the court. But the
Malad, I'm not. If your lordship is minded, not a problem.
Powerless to take the matter if the matter has not been admitted or
Malad,
has not been issued by the master.
Malad, my submission also encompassed, Malad, the sudden demand for an interim order, Malad. I was saying that first your lordship has to ascertain the facts, whether we are addendum or not. That is what I wanted to say. But it was not challenging your lordship. But I was the first person to say that the master's role has come to an end in the commercial suit. If your lordship remembers,
Milord, I have learned one thing from Mr. Chatterjee, that you have a right to move it ex parte so long the other side doesn't appear. If he appears, then you have to serve it. Obviously. But Milord, there is some urgency, Milord. If 5 minutes tomorrow, Milord.
Whenever your lordship.
5 minutes. Well, kindly don't keep it tomorrow, Milord. We have to get it ready only. If they serve, Milord, we have to get ready.
Make sure. So further, anything should not be done if it is matter.
Make sure that nothing
I am not passing any order. Both you and Mr. Ray, the persons are appearing. Make sure that whatever it is, let the court hear, and if the court reject, then
because the evidence has now come surfaced that you are trying to deal with the property. Make
Malad,
sure that
once Mr. Dutt says that evidence has surfaced, Malad, that itself takes away original summons. Straight away. When he says this evidence has surfaced. Because then the facts are not at item, Malad.
Come.
Malad, I will also try and assist your lordship with the judgment which your lordship have been shown, Malad. I will show that, Malad.
Come.
Kindly, if your lordship keeps it tomorrow, Malad, keeps it tomorrow, or Malad, Monday, whenever your lordship. Because Monday, Malad, again, we are in a restricted.
Let them assure.
No. Assurance, Malad, that is something which is. No steps will be taken. I know no steps will be taken, but Malad, assurance kindly does not record, Malad.
Mr. Rai says that he knows no steps would be taken, Milord. It's good enough.
Monday कोई time में है क्या? Fix.
Malad, only till 12, Malad, we've got courts that we have been told.
Monday Corona? Oh, Monday courts are only till 12.
Next Friday नहीं है अभी एक कितना बजे 12:30 fix tomorrow can be Mr. Ray tomorrow at 11:30
yes tomorrow, Milord, I have some difficulty, Milord. I indicated in other matters also, Milord, that tomorrow
Malad, without my leader, Mr. Dasgupta, I mean,
once Mr. Dasgupta, then he will not leave the court.
Malad, may I say this, Malad? On Monday, if you can, lordship can give us 10 minutes on Monday, anytime.
Monday, I have no problem. But your bar is from 12 onwards, they will not come. Correct. That is.
Would it be at 11:30, Malad? 11:30
তাহলে মঙ্গলবার করে দাও
full court is there
11:30
Monday 10:30 কোনো ফিক্স নেই
আরে জজ সাহেব কে দিয়ে ডিসাইড
and Monday 11:30 if possible, Malad, kindly Malad, beseech, Malad.
Monday করো না ফালতু unnecessary
Tomorrow, Mr. Dasgupta can be there online.
16 तारीख को
His justified presence will be justified.
फर्स्ट मिनट में भी नहीं है
There's some urgency, that's why we
10:30
are
तक
so otherwise we wouldn't have
16th को 10:30 रखते
Very grateful, my lord. Very grateful.
The
16/10/30.
The plaintiff has filed the originating summons suit. Full stop. The Mr. Anirban Ray, Leonard, senior advocate, appearing for the defendant and submit that he has instructions to appear in the matter on behalf of the defendants and to accept the notice.
16th, I am not there. 15th, tomorrow, 15th, anytime.
Accept the notice. Accordingly, the plaintiff is directed to serve the notice of the suit of the originating summons suit to the plaintiff to the defendant in course of the advocate on record of defendant in course of the day. Police, let the matter appear on 17th morning 10:30 है खाली 17 at 10:30 as specific 17th অনির্বাণ দা
হ্যাঁ 17
Mr. Ray 17th
তুমি বলে দাও আমরা তো বলছি না না কিছু বলেনি মিস্টার রায় না কিছু বলেনি
No, but I was under the impression that your
His impression.
Okay, come on that
His
day.
impression.
No, that till the courting season of the matter, my lord, that evidence. Now they are denying that we have not said anything.
We don't know what is there. I have not said anything. I am standing like that. He is hearing my whispering and manbati.
Come on 7.
I'm assured, my lord, nothing.
না তুমি একাই শিওর
Huh? Hey,
My lord, application. वहाँ का है.
Application.
And all the three matters, my lord.
Yes, in all three.
Grateful.
But we have taken out 3 applications. We will also serve them.
Along with that, the
Application.
along with the supplementary affidavit application.
Applications also.
Along with the applications.
My lord, they have grown wiser, my lord, on this one, my lord.
You have made us all wiser.
Because I took the point.
Obliged.
Grateful, my lord.
Item number 14. Version original site group. You to লিখতে পারবে?
My lord, I'm appearing for the plaintiff.
I'm for defendant number 1.
Yes.
My lord, last date's order, my lord, we have already completed inspection and discovery, my lord, both sides. I think my learned friend just told me that his affidavit of admission and denial is also ready, my lord, but mine is not ready. I'm candidly submitting, but we are ready with the suggested issues also. So as your lordship pleases, my lord, if I can be granted some time for submitting my affidavit of admission and denial.
How many defendants are there?
My lord, defendants are 2. The defendant number 2 has not submitted written statement.
You are appearing for both.
No, I am appearing for defendant number 2. My learned friend is for
And you are for one.
One.
And
we have the
all parties have filed the suggested issues.
We are filing.
Admission and denial. Defendant number 1.
The plaintiff's admission and denial is not complete, so perhaps that should be completed first before the.
No, I am framing of issues. In the meantime, plaintiff and the defendant number 1. You have given.
I'm not. Number 1.
So who is for the plaintiff? You are for the
My
plaintiff.
lord,
You are one.
yes, your lordship.
So it is maintainable in the present form, and issue number 2 of the defendant number 1 is the suit is maintainable. So these are overlapping. So I am taking the plaintiff's issue number 1. So I am not taking your issue. Now whether the suit is barred by law, and you have taken a specific whether suit is barred by law of limitation. So I am taking the limitation barred by law. Barred by law includes the limitation.
Correct. Includes the limitation.
Includes the limitation. 2 and 3 I am not taking the defendant number 1. So the plaintiff is entitled to the relief. Then 9. Plaintiff 9 and the defendant number 4. Defendant number 1 issue number 4.
Yeah.
So that is also overlapping. So other and your 8 also. 8 covers 9. The plaintiff's claims account from the defendant's incomes of the natural being. That is the main claim.
That's there.
Yes, plaintiff. 8 covers 9.
Yes.
Did it?
Yes.
8 covers 9. So I am not taking the 8. So all then agar
9 covers. Basically 9 covers 8.
9 covers. The defendant number 1 has filed affidavit of admission and denial of document as well as suggested issues. The plaintiff has also filed suggested issues. Let the same be kept with the record. The plaintiff prays for time to file affidavit of admission and denial of the document. That you will not file anything.
I'll also file it on the next date along
The
with
defendant
number one issue. He has not filed a written statement whether his
so what document
affidavit can be accepted in that aspect. Accepted.
So defendant number 2 has
Well,
not
I
filed
will show your
written-
lordships on the next date.
defendant number 2 has not filed any written statement. As such, there is no question of filing document by the defendant number 2. How you will file
How
that?
can he file? I'm allowed to argue.
You
No,
can
he'll be in the
argue. You
cross-examination.
can argue. You can cross-examine, but you cannot disclose the document. Full stop.
Yes.
Considering the submission made by the counsel for the parties, peruse considered होगा. Consider the submission made by the counsel for the parties. Peruse the suggested issues of the plaintiff and the defendant 1 and the pleadings. The following issues are framed. Following issues are this 1, 2, 3, 4, 5, 6, 7, 9. 8 नहीं आएगा और इसका 1 आएगा, 2, 3, 4 नहीं आएगा, 5, 6 and 7. ठीक है. Cool. The plaintiff shall file the affidavit of admission and denial document within a week after the puja vacation.
Great.
Full stop. The parties are also directed to file their judge's brief of document within 2 weeks after puja vacation. Full stop. The plaintiff is also directed to file the affidavit of documents after 4 weeks of the puja
I
vacation.
believe the affidavit of documents is already filed.
Who? Okay, if
With
it
the
filed, then on that day you mention
all documents already filed with the plaintiff.
affidavit of documents. Affidavit of documents. Because it's a commercial suit. Please mind it. You might be filed the affidavit of admission and denial.
Yes. I have filed affidavit of admission.
No, we have not filed yet.
affidavit of admission and denial.
Not filed, no? That's
We have
why.
not filed.
Yes.
You have to file now. Full stop. The affidavit. The plaintiff is also directed to file the affidavit of evidence of the plaintiff within 4 weeks after puja vacation. Please the matter, give the date after serving the copy to the land counsel for the defendants. Please the matter on December. Evidence. 9th December at 2 p.m. for witness action.
Grateful. Grateful. Grateful.
Grateful.
Next.
May it please your lordship, item number 15, I'm appearing on behalf of the plaintiffs. Lordship,
My lord,
Discovery and inspection so far as concerned is complete.
Where is the affidavit of admission and denial?
my lord,
Lordship,
admission and denial in our part it yet to be prepared, my lord. My lord,
Where is the suggested issues?
my lord, it has prepared, but there is some discrepancy with clients.
When you find the discrepancies, which date?
My lord,
For the last 3 months, the matter is fixed for framing of issues in the list.
my lord, kindly.
The month of July, it is fixed.
My lord, kindly post this matter after vacation.
Yes, what about the plaintiff?
Lordship, admission and denial. Lordship, the admission and denial is ready, Lordship, yet to be signed, Lordship. Kindly places this matter post vacation, we'll come back, Lordship.
Parties press for extension of time. Counsel for the party submitted that discovery and inspection with documents have been completed, but press for time, press for extension of time. Extension of time to file affidavit of admission and denial of the document. Let affidavit of admission and denial of the document be filed within a week. Filed after 1 week. 1 week after puja vacation. Full stop. The parties are also directed to file the judge's brief of document within 2 weeks after puja vacation. Full stop. The parties, in the meantime, the parties are also directed to exchange their suggested issues. List the matter on 26th of November 2025 for framing of issues. Next.
Grateful, Lordship. Grateful, Lordship.
I am appearing on behalf of the plaintiff petitioners, Your Lordship.
And for the defendant number 1.
There are 3 GAs on board, Your Lordship. The GA5.
GAs at the time of framing of issues.
Your Lordship, these have not been disposed of. I'll tell Your Lordship. The GA3 is the Order 13A application for which the order judgment is reserved by Your Lordship's predecessor. It's yet to be pronounced, Your Lordship. And GA5.
What is the GA1?
GA1 is for injunction, where there is an injunction order, Your Lordship. Now, GA5 is my application to file additional written statement to the counter claim, Your Lordship. Your Lordship, in a similar matter, Your Lordship had decided against us, Your Lordship, on that issue, whether the 120 days is applicable or not. Now, Your Lordship, we had, in the division bench has also decided against us. We had preferred an SLP. Your Lordship, in that matter, Your Lordship, the stay has been granted by the Honorable High
Court. It's also in the list, Your Lordship, which
that,
is item number 146.
Yes, Your Lordship. Now, the stay has been granted in that matter, Your Lordship. So, if it can be posted, let it go out of the list, Your Lordship.
Yes.
Your Lordship, it is returnable on 16th or 17th this month, Your Lordship. So, let it appear post vacation, Your Lordship.
Counsel for the plaintiff submits that the plaintiff has filed an application being GA5.
GA5.
GA5 2023, praying for extension of time to file additional written statement to the counterclaim. Full stop. Counsel for the plaintiff submit that the issue in question, whether the time to file written statement to the counterclaim and whether 120 days is also applicable to file written statement to file additional written statement to the counterclaim is an issue pending before the Honorable Supreme Court. Supreme Court in SLP number in SLP in SLP within bracket civil diary number 22836/2025 in view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 19th November 2025.
Your Lordship, similar order for item number 146.
The copy of the order passed by the Honorable Supreme Court dated 23rd May 2025 be kept with the report. Yes. Item number
This order, I 146. This order is passed in the suit appearing in item 146 only.
146.
Yes, Your Lordship.
146. But other party is not here.
Your Lordship, same party.
Same party, same.
The 146. In view of the judgment, the Honorable Supreme Court in SLP Civil Diary number 22836/2025 dated 23rd May 2025 stayed the further proceeding of the present suit being CS Com number 440 of 2024 in view of the judgment passed till the next date of hearing. In view of the judgment passed by the Honorable Supreme Court, let the matter go out of the list for the present liberty to mention.
Great.
May it be returnable on the 19th of November?
Stay, how I can fix? Mention if it is okay, if it is set aside, then mention and your return statement will be accepted. If it is upheld, then you think what is to be done. Huh?
That is the end of the road.
End of the road. Now that is good because the issue will be settled. It will be settled.
Otherwise,
And-
it's very difficult. Because
And I don't think the other matter has been challenged.
Yes, yes.
That has been not challenged. Because it has to be settled.
As he ordered it.
Another is there. Okay. Next.
Grateful.
But I am for the defendant, my lord. Lord, my application under my lord order 7 rule 11.
Who is for the plaintiff?
My lord, I am for this item 17, my lord. I am for the plaintiff.
Yes.
My lord, I was here only, but I thought that specially fixed matter will go. So I had left the court. My lord, kindly take it up on Monday, my lord. In that event, I'll do the matter.
As per the prayer made by the council for the
But can it
plaintiff.
be on Tuesday, my lord? Can it be on Tuesday? My lord?
Tuesday. As per the prayer made by the council for the. Now what for what Tuesday? Why?
My lord, they are to my lord reply to my application, my lord.
My lord,
What?
I had given almost the reply I had concluded because they had taken a point that it cannot be a commercial suit. My contention,
जब application है तो फिर क्यों इसमें?
it is an application. And it is a partnership firm to whom the loan has been given. Now they say it cannot be a friendly accommodation loan to a partnership firm.
The defendant has filed an application praying for dismissal of the suit being GA 7
of
GA
2025.
7 of 2025. Full stop. In view of the above, let the matter be placed under the heading adjourn motion on 16th September. Next.
Deeply obliged.
Lord 18, I appear for the plaintiff. Your Lordship had passed an order on 17th of June 2025 for discovery inspection and my lord admission denial. My lord, my
Not
clients, my lord, there's a bereavement in the
Not
family.
done.
My lord, kindly gives us some time after the vacation. We'll not, my lord,
Lordship,
flout that.
some time is required to
You
complete.
also regard as per prayer made by the council for the parties, time to complete the discovery and inspection of the document is extended for a further period of 2 weeks after the puja vacation. Full stop. The parties are also directed to file their affidavit of admission and deny the document within a week thereafter. In the meantime, the parties are also directed to exchange the suggested issues. List the matter on 25th of November 2025 for framing of issues.
Great.
Next.
Only for 5-minute passover, my lord. Mr. Banerjee in court on legs.
Application, my lord, under section 10 of the CPC, my lord, seeking stay of the suit, my lord.
Ready?
My lord, yes, my lord.
10-minute passover.
For
Mr.
what?
Shiv Shankar Banerjee is
It's not
appealing
ready. Whose application is?
I'm for the defense.
Your application. That's why he's not ready.
Lord, I am ready.
You're ready?
Yes, my lord.
Ready?
Yes,
Let's
sir.
start. Okay, you take me. Let Mr. Banerjee come in the meantime.
But the opposition, I don't think they've already filed, my lord, to this application.
This is appearing for the first time.
First time?
Yes.
Appeared for the first time, my lord.
Yes.
GA?
A4.
G5, my lord.
G5, my lord.
G5. Other GAs are also there.
G5, my lord.
What?
Yes, my lord. My lord, other GAs are also there. Your lordship wanted the issues to be framed, my lord. There is a city civil court suit, my lord. Therefore, my lord, we have filed a section 10 application, my lord. I think they need to file an opposition. If they don't want to, then we can proceed, my lord.
Yes,
We want to file.
don't mind.
No, no,
will
we
not
want
file.
to file.
Huh?
We want to file.
want
But
to
since matter
Make it easier, my lord.
first day, and your lordship, there is no order.
Okay. The defendant has filed an application under section 10 of the Code of Civil Procedure for staying of the suit, staying of the proceeding of the suit. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition be filed by
3 weeks.
by 2 weeks after puja vacation. A reply, if any, there to be filed within a week thereafter. Release the matter on 26th November.
Grateful, my lord.
Under the heading adjourn motion.
Grateful, my lord.
Next.
I appear for the plaintiff in this, my lord. My lord, I appear for the plaintiff in this, my lord. My lord, on the previous occasion, my lord had fixed the issues, my lord, and my lord had directed for the affidavit of evidence to be filed. My lord, the affidavit of evidence is ready, my lord. But my advocate on record, my lord, is unavailable today, my lord.
For the defendant. So, okay, I am fixing a date for evidence witness
Yes,
action.
my lord, if my lord allows.
Will file.
Yes, my lord.
Counsel for the plaintiff prays for extension of time to file. Have you filed the judge brief document?
Yes, my lord. I think so.
No, last occasion 4 weeks time was granted.
My lord, it is also ready, my lord. It will be filed at the same time.
Counsel for the plaintiff prays for extension of time to file judge's brief document as well as affidavit of evidence. In view of the submission made by the counsel for the plaintiff, time to file the judge's brief document as well as the affidavit of evidence of the plaintiff is extended for a further period of 2 weeks after puja vacation. Full stop. Let the matter appear. Give the date. 15th December at 2 p.m. 2 p.m. for witness action. Next.
21, my lord, I am for the plaintiff, my lord.
For the defendant, my lord.
And my lord, must say, my lord, I am at fault, my lord. Lordship has already given the direction for discovery and inspection that though inadvertently but stands not complied with as of date, my lord. So, my lord,
that's why I put the issues
when my lord,
for the last 3 months it is
my
going back.
Issues, my lord. But without the discovery and inspection, how can the issue be framed?
That's
Though
why.
we have made our suggested issue.
That's why the court has passed the direction and fixed the framing of issues. But you are not compliant with the first direction.
That part,
so issue will not be framed. Let the suit be proceeded without the issue, without the document.
How can my lord commerce? My lordship knows better. That's why my lord says.
So without document, without issue, the court can decide it.
My lord,
it is up to how you lead the evidence.
But the issue is ready, my lord, but that will be futile without the discovery and inspection being completed, my lord. And at the
I leave it to my lord.
Counsel for the parties prays for extension of time to complete the discovery and inspection with document. In view of the submission made by the counsel for the parties, time to complete the discovery and inspection of document is extended for a further period of 2 weeks after puja vacation. Full stop.
And this time kindly make it peremptory.
Full stop. The affidavit of admission and denial of the document be filed within a week thereafter. In the meantime, the parties are also directed to exchange their suggested issues. Release the matter on 27th November 2025 for framing of issues. Yes, next.
Well,
Grateful.
No, my application.
Give metal.
Lord, taking leave, Lord, to rely on certain additional document in a commercial suit. So discovery was done. This document was there, Lord, not in our knowledge, in the plaintiff's knowledge. But it is not the Lord email.
Without the plaintiff knowledge, how the discovery can be done?
Lord, company was not shut down. It was in the staffs were not in the company. It was not known to the directors. The moment we came to know, we have given instruction to the defendant that we are going to rely on this. If I use the document in the judge brief document, but if a order was passed by Lordship that unless you get a leave from this honorable court, that cannot be allowed. I have not annexed that order of my lords.
Who is for the defendant? Have you served?
Yes, sir, sir.
So this is to become under the heading adjourn motion.
Yes.
But nobody is there. Yes Bank, who is appearing for the Yes Bank? Though the matter is listed under the heading framing of issues, but the learned counsel for the plaintiff submit that the plaintiff has filed an application being GACOM 2,
my lord,
2 of 2025, praying for leave to disclose additional document. In view of the submission made by the counsel for the plaintiff, let the matter be placed in the list of new motion on 19th November 2025.
My lord.
Yes, next.
For the plaintiff, my lord, discovery and inspection is complete. I am informed. My lord, only, my lord, as I am informed, my lord, and instructed, my lord, the affidavits, necessary affidavits are not prepared. Affidavit ready for any. Well, the defendant is proposing to give suggested issue today, but cutting a very sorry figure, my lord.
But what I will do after complete the court work, and I will take all the orders and call all advocates on record. Please do and come.
I was thinking
I have taken I think 35 matters. None of the case either affidavit is not completed or issues are not, the discovery and inspection has not been done. How the suit will proceed? Yes.
My lord, I am the
discovery completed.
My lord, I am the defendant, my lord. Suggested issues we are carrying today, my lord, subject to your lordships.
Discovery?
Discovery is completed.
Then
the affidavit of admission and
discovery
denial.
completed.
Discovery completed.
My lord, I am told the discovery and inspection is completed, but the affidavits of admission and denial have to be, my lord, filed.
So where is the suggested issues you are having suggested?
But I am not having suggested issues today, my lord, but even the affidavit as relating to discovery and admission denial, that is yet to be submitted, my lord.
Your lordship may consider dismissing the suit for default.
Now you got the point today. A good point for dismissal of the suit. What is your answer on that?
I don't know, my lord, whether that would be a tenable one or not.
The counsel for the plaintiff, counsel for the parties, press for time to file affidavit of admission and denial of the document. The counsel for the plaintiff also pressed for time extension of time to file suggested issues. Though the learned counsel for the defendant submit that suggested issues with regard is ready. Foolish. In view of the submission made by the counsel for the parties, time to file affidavit of admission and denial of document is extended. Before vacation can do?
My lord.
Sure.
We have to do. That's why the odd impression is all on us.
My lord, kindly, my
Within
lord.
a week after Puja vacation.
Great.
Within a week after Puja vacation. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 12th November for framing of
My lord, we have already handed over the suggested issues.
Come on.
Next. So your lordship takes up the next matter, my lord. Item 20, my lord, it was only for
Item 20?
Is here, my lord.
Item 20 is over.
Yes, my lord. My lord, could not reach, my lord. My lord, nothing has happened, my lord. They had only prayed for, my lord, extension of time to file the affidavits. My lord, lordship will kindly, my lord, record my, my lord, appearance. My lord, my appearance, probably, I could not reach the court, my lord. That is why, at that time.
My lord, if my lord another accommodation, my lord, if my lord appoints a commissioner in that matter, my lord,
I'm not standing in the way.
My lord, that would also expedite the suit also to an extent.
You do one thing, you mention the matter, tomorrow or day after tomorrow, both come and I will appoint that.
Thank you.
Better fix at 12:30. Item number 3 for the non-commercial.
Yes, not for not appearing yesterday.
Yes, no.
Probably this it is yesterday.
Yes.
My lord, on the last occasion, I had taken your lordships through the
PW2, Your Honor.
PW2 and PW3, the attesting witnesses, my lord. And thereafter, I had started taking your lordship
DW2, sorry.
through
DW2.
the evidence of DW3, 2. My lord, he was the custodian of the will and he was called by my learned friend by way of subpoena, my lord. Lordship, just give me a moment's time. No. My lord, I had also placed the exhibit.
Exhibit 1. Exhibit I.
I, my lord, which was the letter which was written by the defendant to the
Claiming the
propounder.
50% share.
Yes. My lord, thereafter, if your lordship takes up exhibit J, the reply. J. I দিয়েছি J. My lord, exhibit J is a letter written by the witness himself, addressed to Mr. Gothakurta at the instruction of the propounder, my lord. The first paragraph, if I don't want to place the entirety of the letter, 2 paragraphs I want to place. First paragraph, my lord. At the outset, my client states that she and her husband were very much disturbed with the cruel and inhuman. I need not place this. The next sentence, under the circumstances, your client's father, my late husband, completely disowned your client as declared in his last will and testament. According to the said will, your client is not entitled to inherit any of the properties. Under the circumstances, the purported claim made by your client are not tenable. My client will be taking proper steps for obtaining the probate of the said will in accordance with law. Immense damage has been done to your client by your client to the reputation of his father during his lifetime. I need not proceed any further, my lord. The only reason I want to bring to the notice of the court this document is that it has been submitted and a impression has been sought to be given before this court that the son was not aware of the will. But he was very much aware, much prior to the filing of the probate proceedings, my lord.
Yes.
Now, my lord, the next exhibit is Exhibit L. The letter written by my learned friend in reply to that document. No, my lord.
Exhibit L is again the letter of your reply. Your reply to the
My lord,
letter.
these are, I need not place this. These are in correspondences exchanged between the advocate on record of the defendant and the custodian of the will, who had come to the box and deposed before your lordship, my lord, that the will was drafted by him at the instance of the testator, and the testator, after going through the will, had made certain corrections and kept the will with him, got it executed, and thereafter he had again called the witness and kept the will with him in a sealed cover, and instructed him that if he expired before if he predeceased his wife, then the will should be handed over to her. But that is what exactly happened, and I have taken your lordship through the evidence, my lord. Now, my lord, while cross-examining examining, I will not use the term cross-examining. Ideally, it should have been mentioned as cross-examine, but I had also examined the custodian of the will, my lord. Let me take your lordship through the evidence that was recorded on behalf of the plaintiff, my lord. 13th May 2024, my lord. Yes. Question number 29.
Yes.
Shown Exhibit I in the instant proceeding whether this document was received by you. Yes, this letter was addressed to Srimati Tapati Sengupta, by Mr. Kollol Guho Thakurda. Tapati Sengupta handed over this letter to me with the instruction to reply. Did you give any reply as instructed? Yes. Shown Exhibit J. Yes, this was the letter dated 24 January 2012, addressed to Mr. Guho Thakurda on instruction of Mr. Sengupta. Are the contents of this document true and correct? Yes, as per instruction, I had prepared the letter. Shown document marked as Exhibit K. Yes, this letter dated 10th February was received by me from Mr. Kollol Guho Thakurda. Did you give any reply to the document? Yes, I remember I had replied. Shown Exhibit L. Whether this is the reply you had given to the document being Exhibit K, this was my reply. Letter dated 18th February, addressed to Mr. Guho Thakurda, and it bears my signature. This letter was addressed as per instructions. My lord, there were several other documents which were interchanged between the advocate on record of the defendant and the custodian, my lord. All of them have been collectively marked as Exhibit M, and a perusal of these documents would give the clear picture that all along the original defendant was aware that there was a will, and the will was to be probated. He had received a copy of the will also. Now, my lord, with this, the first limb of the objection that the will was not properly executed by the testator I think has been dispensed with, because I have taken your lordship through the evidence, the attesting witnesses evidence, that the will was executed by the testator. The attesting witnesses were present and they have seen each other while the other one had put their signature. In presence of three of them, the will was executed. Thereafter, my lord, the will was kept with Mr. U.S. Menon as a custodian of the document.
Yes.
Mr. Menon had come to the box. He had deposed that the will was prepared by him at the instance of the testator, and thereafter, after the will was executed, it was handed over to him again to be kept in safe custody, and after his death, it was to be handed over to his wife. Not that part, and I have taken your lordship to the cross-examination also. I have indicated to your lordship, my lord, the places where they have accepted the will as well as the signatures, my lord. Now the next part is their objection. The second limb of their objection is fraud, coercion, and incapacity of the testator. My lord, I would again rely on the evidences which I have taken your lordship through, that in all the three evidences, the witnesses had said that the testator was working, he was doing consultancy, he was giving opinion and advices, and that itself is an indicator that the brain, the mental health of the testator was all right, my lord. Secondly, my lord, the testator had executed the will.
That is also not the.
My lord, one liner has been stated in the
argument.
Written statement. That is why I indicated that to your lordship.
But in the cross-examination, it is not the question that it is not fit statement.
No, it has not. Nothing has been borne out from the cross-examination. No such questions were given. Neither has the witness on behalf of the defendant come to the box and said that he was. There are a few questions which I don't need to take your lordship through. Okay. Is that they have said he was not physically, he had some problem without any particulars. দরকার নেই Now, the second thing, that the will was executed under coercion. But that part also, the will was executed sometimes in 2008. The testator expired in 2011. It is borne out from the entire proceedings and the records that the testator was Helen Harty. He was traveling from one place to another. As he expired in USA while he was visiting his daughter, my lord. Under all this, and he was an ex-judge of this court who had a mind of his own. My lord, from 2008 to 2011, if the will was executed under coercion, my lord, the testator could have changed his will. He has chosen not to do that. And I have placed the will also before your lordship. The reason why he has not included his son in the will. That has been categorically stated. And subject to correction, my lord, there is nothing on record on behalf of the defendant to nullify that. There are mere allegations that the propounder, being the stepmother, had misbehaved, has tried to impress upon the father to deprive the son. He was controlled by his second wife. All those suggestions have not been supported by any documentary evidence or any cogent document or particulars from which that can be borne out. Now, let the knowledge of the will. When the witness came to the box on behalf of the defendant, DW1, my lord, on oath she has stated that she had no knowledge of the will. But I have taken your lordship through this indicated exhibit. If your lordship takes a note of exhibit I to M,
Yes.
it will be crystal clear that they were fully aware of the will. My lord, question 47.
47
of the DW1, my lord. It was recorded on 17th of November 2023.
Namely, what is the name of the DW?
Manoshi Sengupta Bhadra.
$40.
47, my lord. Shown the original will. Mrs. This is in examination in chief.
Yes.
Mrs. Sengupta, please check whether this document being the original will carries the signature of your father-in-law or not. First of all, I do not accept the existence of this will because my father-in-law had told me that he had not executed any will in his lifetime. Now, my lord, I want to give the background. My lord, the son had left the residence long time back. The son, the testator and his wife, they were not aware of any marriage which has taken place between the present defendant and the original defendant. It is on record that neither of them attended the son's wedding, and there is nothing on record to show that they were invited or they had any knowledge that the son has married. They had tried to intrude into the residence of the testator and the propounder a few times, but there was no relationship between the testator and the son and his wife, and none of them recognized her as his wife.
Yes.
Now the next question. Mrs. Sengupta, just see the schedule of the property mentioned in the affidavit of assets. Can you understand what is written over? No, I cannot understand what is written over. According to this affidavit of assets, Justice Sengupta was not having any other property apart from Ashok Nagar property. Do you agree? I do not agree. Well, I don't want to take your lordship through the entirety of the evidence. Well, that would be wasting your lordship's time. But a perusal of the entire records will show that she was never residing with them and she could not have had any knowledge about any of the details of the properties or the assets of the testator, firstly. Secondly, she has tried to make out a case that her father-in-law was very fond of her and he has gone out of his way to discuss these things with her. Those are from the bar, my lord. There's nothing on record to substantiate that. Now, my lord, in cross-examination, there are few questions I would like to indicate. My lord, question number 74. They recorded on 30th November, my lord. Question 74, my lord. Were you aware of the kind of relationship your late husband had with his late father before your marriage? Yes, I was aware. What kind of relationship they shared? Normal relationship which a father and son shares. So I can take it that before getting married, your father-in-law was intimated by your husband of his decision to get married. Yes, he was intimated. Was your father-in-law present at the time of marriage? No, he was not. Let us pause here for a while. Well, only son, he is getting married.
Father was not.
In our culture, the father is always there if the relationship is good.
Yes.
The stepmother might not have gone, but the father would be there. Was your father-in-law present at the time of marriage? No, he was not. You'll agree with me that the normal relationship between father and son, it is expected that father would be present at the son's marriage. I do not agree. As our marriage was held at Jalpaiguri and father-in-law could not attend the marriage. My lord, he was a resident of Calcutta and his son has left for North Bengal. He was residing there. This is not a great distance to travel. And they have not produced one single document where from it would be evident that the father was invited, a card or any intimation, any letter, nothing on record, my lord. Before marriage, were you introduced to your father-in-law and stepmother-in-law by your husband? No. After your marriage, did your husband take you to your father-in-law's residence? Yes, he had taken. Do you recollect when you visited your father-in-law's residence after your marriage for the first time? Date I do not remember right now. Did your father-in-law bless you? Yes, he did. Can you tell us as to what your, well, irrelevant. Are you aware since when your late husband was residing away from his father? Question number 84, my lord. From his childhood at the age of 6, he used to stay in hostel at Asansol. Since then, he had been staying away from his father. Now, my lord. Now, my lord, the evidence led by the defendant that there was no will. If your lordship just takes a look at question number 159, this was recorded on 1st December 2023.
Yes.
Have you disputed any document? This has to be disclosed. Have you disclosed any document or any record in the instance proceeding where from such claim made by you that your late father-in-law had never made any will? No, my advocate can say better.
Yes.
My lord, a question was put forth by the court, my lord, question number 161 onwards, my lord. Between February 2008 and prior to the death of your father-in-law, how many times you and your husband visited your father-in-law? I have not counted the number. We used to visit my father-in-law twice in a year. Whenever you visited your father-in-law along with your husband, what transpired at the meeting? We used to have very brief interaction. Contradictory, my lord. Did your husband, to your knowledge, take any steps after receiving a copy of the will from Mr. U.S. Menon? He has challenged the will. When was the challenge made for the first time? I do not remember the exact date. The date would be reflected from the document itself. Was the challenge made prior to filing of the application for grant of probate or subsequent thereto? Right now, I do not remember. All these questions are questions put forth by the court, my lord. To your knowledge, when did your father-in-law demit his office of judgeship? I do not know exactly. Was it before making the will or after making the will, which is sought to be probated? He never made his will. He had already retired by that time. Honor before your marriage was fixed with your husband. Did your parents had any interaction with your father-in-law regarding marriage? Before our marriage, my late husband had called my father-in-law over phone. My parents expressed their desire to talk to him over phone. My aunt in-law,
My aunt of my father-in-law.
the aunt of my father-in-law used to stay in Beala. She would talk as guardian on their behalf. My parents had talked with the aunt of my late father-in-law. This gives a clear picture that the father had nothing to do with him.
Yes.
Now, only one question. My lord, if your lordship takes up 30th November 2023 once more, my lord, question 91. It's on a different point, my lord, that
'91.
yes, my lord, the coercion on the on coercion, my lord. So can I take it that you are trying to say that in presence of your stepmother-in-law, your father-in-law had informed you that he was forced to sell Mandevilla Garden property due to undue pressure created by your stepmother-in-law? Yes. Nothing on record. My lord, in that event, this should have been reflected from the written statement filed by them.
You can take you. It is a cross-exam? No,
Yes, my lord.
It is a chief
Cross-examination.
cross-exam. So I can take it that you are trying to say that presence of your stepmother-in-law, your late father-in-law had informed you that he forced to sell. Yes.
My lord, there is nothing on record in the written statement which will be borne out from this. Now, the next question. You have deposed earlier in your examination in chief that one Mr. U.S. Menon had handed over a copy of the will of your late father-in-law. Do you recollect that? Not to me, but to my husband. Lord, she was brought on record subsequent to the death of her husband.
Yes.
So it is established that they had a copy of the will.
Yes.
Where were you when the said will, as deposed by you, was handed over to your husband? I was in a hotel room. Absolutely concocted stories. Nothing on record to show or substantiate as to what has been given by way of evidence, my lord.
Yes.
Now, my lord, if your lordship takes up the evidence recorded on 4th of December 2023. My lord, regarding physical fitness. Question 173. Mr. Bhadro, you will agree with me, Mrs. Bhadro, you will agree with me that your late father-in-law was physically fit enough to visit United States of America in August 2011. He did visit America, but he was in good health at that time. I suggest it to you that in the written objection filed by your late husband, there is no mention of such invitation tendered by your late father-in-law to your husband or yourself to come and meet him. I am not aware of it. My husband will be, my advocate will be in a better position to say. In answer to question 23, question number 176.
Yes.
You have deposed before this honorable court that you were pressurized by Mr. Gautam Mitra to withdraw the caveat in lieu of 3 lakhs of rupees. My lord, all concocted stories which do not find any place in the written statement. Yes, I do remember this was not told to me but to my husband. The witness had no knowledge. When she comes to the box, she says she was pressurized, and when she's cross-examined, all she says that I was not aware, my husband was aware. My lord, after the amendment of the plaint, my lord, when she was brought in as a party, she did not file any other written statement, bringing on record these facts. She merely adopted the written statement filed by her husband, and she has no personal knowledge of anything that had happened. My lord, the ground in the written statement was, my lord, in paragraph 9, it has been stated, if I may please, my lord, I do here, be that as it may, I do hereby most humbly and respectfully state and submit before your lordship that the entire will in question is absolutely vague, untrue, false, forged, fabricated from its very first line to its very last line. The signature as well as initials as depicted on the face of the so-called will are also absolutely false and forged. The so-called will in question also does not include the detail of various other properties. My lord, in a will, it is the wish of the testator to include whatever property he wants to add. None of the parties to the proceeding can have any say in respect of the properties which were included in the will.
Correct.
Do not include the details of various properties duly owned by my deceased beloved father. And the only other ground, my lord, if your lordship takes up paragraph 10, my lord, the so-called purported will is very much motivated, malafide, manufactured, purported, and concocted from its very sum and substance. Now, my lord, so far as the forged and fabricated part is concerned, my lord, I think I have taken your lordship extensively to the evidence. And my lord, your lordship had seen that the witnesses, attesting witnesses had come and they were cross-examined, and I have the extent of cross-examination I had also placed before your lordship. Now, my lord, a will has to be proved according to section 63 of the Succession Act. My lord, the Succession Act to the Succession Act. Indian Succession Act.
रेड कलर का ऊपर थर्ड बुक देखो. Yes.
There are 3 conditions. The testator shall sign or shall affix his mark on the will, or it shall be signed by some other person in his presence by his discretion. The signature or mark of the testator or the signature of the person signing for him shall be placed that it shall appear that it was intended thereby to give effect to the writing as a will. The will shall be attested by two or more witnesses, each of whom has seen the testator sign or affix his mark on the will, or has been some other person sign the will in presence of the direction of the testator. My lord, the third clause, I have demonstrated before your lordship, my lord, that the testator, it has been
Signed by the, in presence of two witnesses.
both the attesting
Attesting
witnesses,
examine.
the requirement is that one, at least one has to come. But in this case, both of them came. Both of them have submitted that they were present at the time when the testator had put his signature as well as his initials on two other pages. They have seen the testator sign. Each of the attesting witnesses have stated that they have seen the other attesting witness put his signature on the will. So now this requirement is fulfilled. And while in cross-examination, there has been no dent on that witness evidence that has been put forward by the attesting witnesses, my lord. Now, in this regard, my lord,
Party hai. Actual 1 p.m. matter is there, madam.
and may I
How much time will take further?
another maybe 15-20 minutes, because I have to see, take your lordship through the judgments. Or any short date before the pujas, my lord, I want to complete.
Record. Counsel for the plaintiff argued the matter at length, but due to paucity of time, hearing could not be completed. This is the matter. Give the date. अभी है कब है? 22nd September at 12:30. 22nd at 12:30. ये original exhibit रख लो. Come on, 22nd.
Item number 7. My lord, 7 and 8 for the application. My lord, I am led by Mr. Basu. He is online.
My lord, may I have my lord's leave to, my lord, address my lord through virtual mode?
Yes.
My lord, this is, my lord, pursuant to my lord's direction, my lord, we have received, my lord, the documents. My lord, am I audible, lordship?
Yes, yes, yes.
My lord, am I audible?
Yes, yes, you're
My
audible.
lord, my lord, pursuant to my lord's directions, my lord, I'm grateful. My lord, pursuant to your lordship's directions, my lord, we received the documents only before, my lord, day before yesterday, that too in the second half. My lord, though there was a direction to the department to give us a document before, but anyway, my lord, we understand, my lord, there are certain, my lord, huge voluminous documents. One thing is very clear: the police, what the report that the police has filed, well, that only provides the current state of affairs. Now, police has only gone there and find out that who are presently the tenants.
Correct.
Now, my lord, that report auspiciously, my lord, could not indicate that who were the tenants in between 2013 to 2021, and particularly with regards to the private tenants, my lord, in respect of whom, my lord, we have said that there are persons, my lord, and if your lordship would please to see, the Shudipta Maiti, my lord, now since deceased, has deliberately said, my lord, that so far the induction of private tenants, my lord, all are, my lord, have come
Mr. Basu,
from 2022 onwards.
Sudipta that Maiti is not there, so first the steps is to be taken. How the matter can be proceeded further.
Exactly. Well, that is what I say, my lord. My lord, what I would request your lordship, my lord, since my client is also one of the beneficiary, she is also the daughter, my lord, in terms of the will, my lord, she is entitled to. Now, so far the calculation and apportionment, my lord, what is to be done, and how much money is, my lord, my client is entitled, what was not given to her. Malad, in pendency of that, Malad, late since Malad already 1 month is also gone. So
Now,
the rate.
what about the legal layers of this Methi? What is the lady name?
Maiti.
Maiti.
Sudipta Maiti, man.
Yes.
Sudipta Maiti.
Yes.
Now, Malad, on the last day, your lordship may recall that my learned advocate has submitted a letter to your lordship's record that we intimated we wanted to know the details of the particulars. The advocate on record of Sudipta Maiti initially refused. Then he said that very well, I will talk to counsel and report. Then he said that my counsel said that not to interact and not to give any information.
Mr. Basu, your client is also the sister of Sudipta Maiti. She might have been knowing these details of the legal layers of the deceased. So you take steps. You take appropriate steps.
Correct, lordship, but the situations are so prevailing between the sisters that, and so far as my client is concerned, as I am told, there had been no even distant relationship between them for the first at least more than a decade.
No, whatever.
So
but you have to file an application. You have to take steps first. So how after the death of the one person, how the case can proceed further, and all the consequential order cannot be passed. Only on that they have taken the matter because of the submission of the report. So no party will be affected. But now if any order passed, it will be affected the other parties. So let the legal your client is a sister. She might be knowing the details of the legal layers.
What I say, the advocate on record of Sudipta Maiti was already there.
But now see what the advocate on record will do. Once the person died, what the advocate on record will do? Advocate on record will not go to the house of the deceased person and collect all the other person are not coming. So it is your duty if you want to proceed with the matter. Otherwise, what can be done? You have to file an application, then the opportunity is hearing to be given, and further course of action is to be taken. Order can
that is one part. Absolutely, admittedly, that is one part. Now,
Correct.
so far the other part is concerned, so far the managing of the property. What your lordship has indicated on the last day.
Correct. But at this stage, it is not. If you are not taking steps with regard to the legal layers, and you are telling that you should be appointed, so then tomorrow I will appoint it, and you will not talk. Who will take the responsibility of the same? Already there are so many hodgepodge has been done in the matter.
The records. I am not a third party.
Now this court has brought this case in to some extent, but now the Sudipta Maiti died. So some person has to be on record.
I understand.
If no legal layers, the court will pass appropriate order for administrative. But the legal layers are there. What can be done?
There cannot be any administrative pendentility, because since the other sisters are present. So what I most humbly request your lordship, since after the month of August, we are on month of September, so that the rents are to be paid by the tenants and it is to be collected.
Well, the last occasion your lordship was directed to clarify some person to the BSNL. Well, kindly see. Prior to that, my lord, kindly see my last affidavit, last date. My lord, at page 60, my lord, not this affidavit.
Yes.
My lord, the page 60, my lord, I have stated that your lordship got it, that page 60, my lord?
Yes.
Column, my lord, the column 5 to 8, my lord.
Yes.
Column 5 to 8, my lord. That indicating, my lord, the May 20, 10,000 to 1 lakhs area, and my lord, the 4 column areas. My lord, the area rent was paid at that time 4 lakh 28,600, my lord. And my lord, I have clarified by this affidavit, my lord.
These are the areas of that which were not available.
Yes, that have clarified, my lord, giving the details. Kindly take it, my lord, the paragraph 5 of
number
2013
to number 2013 to June 2017.
Yes, sir.
Okay, okay, got it.
Kindly, for a moment, kindly see, my lord, just now I have filed this affidavit, paragraph 5, my lord. That I have stated that the total amount, my lord, the 15,81,842, including paragraph.
May we have a copy of it?
Yes, 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 you will get, you will get. Okay, you do one thing, you give the copy to the other
Yes,
side.
yes.
Okay. So what, Mr. Basu, what you suggest with regard to the death person?
My lord, since your lordships observed, my lord, we shall take out, my lord, we shall
And you prepared the list of how many tenants are there as per the reports?
My lord, we have prepared the list. It is
And my
required
lord,
to tell
one
you with
thing,
my
another
client,
thing.
my lord.
Hmm.
It is required to tell you with my client. Only day before yesterday we have received.
my lord, only one thing, well, one thing,
thing.
lordship, that since the report has not yet come, this some part of the BSNL report was about to come.
Because Mr. Basu, my contention, I am telling that you prepare the list, how many tenants, how many rent, prepare so that I can pass an appropriate order for the time being, whosoever be the administrator, so collect all the rents. So
My lord, then my lord, kindly keep it on Tuesday, my lord. By this time, my lord, we shall prepare.
And bring on that, and the BSNL already given the clarification. The copy will be given to you. Also, you consider that also, and I will pass a prepared order. And in the meantime, you
Very
also
good.
take the steps on that day.
Very good. I think Mr. Hossain can certainly talk to
To
the
our
client
knowledge,
and
she left her husband and only son.
Whatever it is, they have
According
to
to
brought
our
on record.
knowledge,
They
but
have to
we
brought on record.
yes.
So it is all also for your benefit.
My lord, my lord.
Correct.
My lord, in the meantime, dust.
That's why I'm telling you, bring the list. You bring the list. How many tenants? Because as per the report, it is clear. How many tenants? Who are they? Who are, then I will pass a
Payment
prepared
of
order.
common electricity meter.
That's why all the things. Then I will pass a prepared order. Whom should be the administrator for the time being, or a special or whatever it may be. So let the list come on the
My
basis
lord,
of
we
the
have
list.
prepared and we will tell you with my.
Yes, Mr. Basu.
yes, my lord, kindly keep it on the Tuesday. I believe, my lord, Mr. Hossain can collect. And my lord, one more thing, my lord, we shall also prepare a comprehensive list. So far, the rents that being paid from 2013 to till date, and my lord, with regard to our apportionment, my lord, and the entitlement out of the same.
That you prepared separately, but you prepared a list. At present, how many tenants are there who are paying the rent, so that I can pass an appropriate order for the special officer, administrator, whatever, and payment of the municipal taxes and electricity charges and whatever it may be.
My lord, one more thing.
Direction, my lord.
One more thing.
My lord, one is, my lord, that I have paid the rent till July 2025. So, my lord, what the BSNL will do from the August.
That's
and
that's
my lord, another thing, by your lordship order on the 2nd September, your lordship direct me to file the vocalatnama and affidavit of competency in course of tomorrow. But my lord, what happened, my lord, I could not get the copy of the website copy, and that I received on, my lord, 3rd at night. So when, my lord, I am produced on 4th, my lord, the department was denied to accept. So, my lord, kindly, my lord, at least, my lord, 4-5 working days may be given, so that, my lord.
Okay. The Learned Counsel appearing for the BSNL authority have filed the supplementary affidavit in compliance with the order dated 2nd September 2025. After serving the copy to the Learned Counsel for the applicant, let the same be kept with the record. Learned Counsel for the applicant prays for 2 days' time for preparing the list to ascertain at present how many tenants are in the suit premises and what are the rents and what are the and for payment and regarding the payment of the municipal taxes and electrical charges on any other taxes of the premises in question. Full stop. Counsel for the in view of the submission made by the counsel for the applicant, let the matter appear. कोई टाइम है फ्राइडे क्या तारीख है 19 last हो जाएगा
My lord, my lord, may kindly keep it on, my lord, next week, my lord, 17th.
No, 19. Come on, 19 as a item number 1. Item number कोई fix तो नहीं है 2 बजे कोई fix तो नहीं है कोई fix तो नहीं है ना 19 at 2 p.m. at the top. Counsel for the BSNL is granted liberty to file the wakalatnama in the department along with the affidavit of competency in the meantime.
Within my lord?
Grateful. In the meantime, till 19th.
Yes, yes.
May I, my
Grateful.
lord, I leave to mention item number 92, my lord, commercial side. Lordship, we take
I'm grateful.
And my lord, the next day our presence is required, my lord, on the BSNL's presence.
Come, we'll see to that. Let them give the reply to that.
Lord,
Item number?
One indulgence, but I'm mentioning the same matter. But 92 of your lordship's commercial division list today. But this is the doors matter, my lord. I'm the plaintiff. The defendant is State Bank of India.
We are appearing for the defendant.
Yes, my lord, the interim order is due to expire today.
Today?
Difficulties, my lord. The injunction, we are suffering an injunction order. Kindly fix a date, my lord.
Counsel, item number 92. Counsel for the plaintiff submitted press for extension of the interim order. Counsel for the defendant submit that due to the interim order, the bank is suffering, facing difficulties, and he prays for fixing a short date. In view of the submission made by the counsel for the parties, come after vacation.
My lord.
एक डेट है सर आफ्टर वैकेशन को एक डेट दे दो you have to give the reply only na
No, they haven't concluded.
Not concluded.
They haven't
one
concluded.
that
But the SBI MSME.
MSME.
Yes.
Yes.
You are giving the reply.
Yes.
11 November at 3:45 p.m.
Grateful.
Full stop. Interim order is extended till 14th of November 2025 or until further order whichever is.
Deeply obliged.
May I be permitted to mention on item number 96 of the commercial data? My lord, this is plan for the judgment data, my lord. He is present in the court today. My lord, now he's in some financial difficulty. He has taken up a job. Previously, he was doing a business. If my lord fixes up any days.
96.
96, my lord, of the commercial execution case. My lord, we had given our affidavit of asset. He had to be examined. My lord, if my lord fixes up any days, then he will come on that day. Otherwise, he has to stay and he incur hotel expenses.
Where from he come?
Dhanbad, my lord. His financial
Which
condition.
matter? That one?
That, yes.
Oh.
My lord, he's here today. He's here today. If
item number 96. That the as per the prayer made by the counsel for the judgment debtor. ये देखो फर्स्ट वीक का कोई डेट है क्या नंबर अक्टूबर 28-29 हैं और एट उससे पहले कोई नहीं है 12:30 नहीं रखे 17 नवंबर 17 नवंबर at 3:45 p.m.
Grateful, man.
Your Lordship, if you may allow, can I mention item 7, Your Lordship? It was passed over in the morning. Your Lordship, the bench had a query that where is the proof of service? So, Lordship, if you may have the notice of motion, Your Lordship. On that page, Your Lordship, there is a receiving.
Now, when it will matter, will be listed. You come, yes.
Notice of motion was there.
Come next tomorrow.
Grateful, Your Lordship.
Lordship.
Of?
Your Lordship's list in the appellate side only. 157. Your Lordship, I am only seeking for it to be dismissed as infructuous because that writ is from
You are preparing for?
the petitioner, Your Lordship. That writ is from non-adjudication of the appeal in RTI by the Information Commission. But now it has been decided and it has been disposed of by the Information Commission. This is the order, Your Lordship. Hence, it has become infructuous. 157.
What is the name? Mahendra Kumaran?
Karnani.
Mahendra
Yes.
Kumar Karnani.
Yes, Your Lordship.
So you have filed this writ petition challenging the order
The
of
second, since it was not taken up by the Information Commission, Your Lordship, in under RTI, but now it has been taken up, it has been disposed of and decided.
A
And
copy of the writ? No.
Yes, Your Lordship. आगे.
Though the matter is listed as item number 57 of today's list, but the learned counsel for the petitioner has mentioned the matter and submits that the writ petition filed by the petitioner has become infructuous in view of the order passed by the law officer and joint registrar, West Bengal Information Commission. Is in view of the submission made by the counsel for the the copy of the order dated
22nd July
2025 be kept with the record. In view of the submission made by the counsel for the petitioner, the WPA 9514 of 2025 is dismissed as infructuous.
Lordship, item number 52. I am for petition.
Item number
52.
52.
I am for paying after vacation.
52.
52. I am
Who is for the other side?
Oh my God. I am petitioner motion. I am for petitioner.
Why after vacation? What is the matter?
There's some difficulty, my lord. According to instruction of the two brother fighting, out of court settlement is going on, not complete.
52 record in order. As per the submission made by the counsel for the petitioner, case is adjourned. Let the matter appear after puja vacation.
My lord,
My lord, may I be permitted to one matter, my lord? My lord, item number 136 of your honor's list, that matter is already fixed on 15th September along with another matter in the Court of Justice, Amrita Sinha. This is the order, my lord.
136?
Yes, my lord.
Item number 136. Counsel for the petition has handed over the copy of the order passed by the coordinate bench dated 1st September 2025 in WPA 26167 of 2024, wherein the Honorable Court has directed to list the matter on 15 September 2025 along with WPA number 8975/2025. In view of the order dated 1st September 2025, WPA number 8975 of 2025 is released from the list of this court with the liberty to the petitioner to mention before the appropriate court.
Grateful, man.
Yes, call the list.
Advocate on record is not present today. One of his relative died today, so I'm praying not this.
This court, it will not help, my lord. Once the matter is listed before this court, either you to do the matter or you withdraw the case.
No, one of his
This
relative
court is
died.
allergic to the adjournment.
My lord, if I may assist your lordship.
Because of the disposal of the matter, this court has to segregate the list of the original side and put the matter of the appellate side. If you are taking, then I will write a letter to the Chief Justice not to place all the matter before this court.
It's an emergency, my lord. One of his relative died today, my lord.
Relative died, counsel is there.
No, my lord. He's appearing. My lord.
As per the, then what do you want?
No, not this week, my lord.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 25th of September 2020. No, 18th September.
Great. My lord, I'm appearing for the petition.
I'm appearing for the respondents, Union of India.
Yes.
Real, my
My lord, the issue in this matter is, my lord.
You are for the petitioner? Yes.
My lord, the issue in the matter, writ petition is, my lord. My lord, I say, my lord, the certificate proceeding which has been initiated under the Public Demands Recovery Act, my lord, it is not maintainable, or the certificate officer has no jurisdiction to initiate any proceeding.
Why?
May I tell your lordship, what happened, my lord, government, Ministry of Railways, in its realm of, my lord, entering into private contracts, my lord, commercially, my lord, enter into contract with us, my lord, for display of hoardings. Now, my lord, a dispute cropped up between the parties. Now, my lord, by virtue of that dispute, my lord, we preferred a suit. My lord, out of that suit, and first miscellaneous appeal was brought before this court. Now, my lord, this honorable court in the first miscellaneous appeal has said that if I wish to continue with the business of display of hoardings in railway platforms, then I have to pay ad hoc till the dispute is resolved an amount of rupees 70 lakhs. Now, my lord, I wrote after passing of this order, I wrote a letter to them saying that even after this order, I am not being allowed to do the business. Therefore, I do not wish to continue the business. Now, my lord, they accept this letter. My lord, all of a sudden, my lord, I receive a notice, my lord, from the authority under the Public Demands Recovery Act that 70 lakhs and odd is due, and you are directed to pay that amount. Now, my lord, I participate in the proceeding for some time, and my lord, later on, my lord, I raised an issue before the certificate officer that, look, you do not have the jurisdiction under the Act. Now, my lord, as that was not considered or, my lord, heard, my lord, I approached before this honorable court in writ petition. This honorable court at length, hearing, my lord, both the sides, have directed specifically the authority to decide onto its whether it lacks inherent jurisdiction or not by virtue of, my lord, the provisions of the Act. Now, my lord, while on relegating the matter to the authority once again, my lord, now the authority passes an order, my lord. First, my lord, my submission to that order which is under challenge in this writ petition is, my lord, this is absolutely unreasoned order. Now, my lord, why I say so, my lord? Because, my lord, under the Act, my lord, to be a public demand, it has to be qualified under section 3(6) under the Act. Now, my lord, 3(6), when I refer to, my lord, I refer to the Schedule 1. Now, my lord, Schedule 1, my lord, if none of the, my lord, claims fall under that schedule, my lord, it doesn't become a public demand. Unless, my lord, specific statute says any amount, just like in corporation, my lord, Kolkata Municipal Corporation, the tax due will be treated as a land revenue. Such type of averments are not there. It doesn't become a public demand. Now, my lord, my submission is, my lord.
So what will happen if there is a due pending against you?
Now, my lord, my first submission to that. My lord, this is a private contract, my lord. This is, my lord, he has a right to recover or come before the honorable court because that FMAT is still pending. Now, my lord, he can come before this court saying that he has not complied with the order. My lord, first the order is, my lord, conditional. The condition is that if I do not wish, I wish to continue the business, then I pay. If I do not wish, I need not pay. My lord, I said I do not wish to continue. So there is no question of paying. Now, my lord, second, my lord, suppose government in a fight of suit between both of us, my lord, he gets a decree in my favor. of money. Now, my lord, what is the remedy? My lord, execution, money recovery, execution. My lord, he doesn't have a benefit under the Public Demands Recovery Act to go and, my lord, chase after me by issuing a certificate proceeding. Otherwise, my lord, there is no requirement of execution. My lord, Public Demands Recovery Act is applicable if the money payable is a public demand. Otherwise, this act has no manner of application. Now, my lord, kindly takes up the, my lord, pages, my lord, of the writ petition. My lord, I take directly, my lord, to the order pursuant to which they say it's a public demand.
Where is the imping order?
My lord, page 83.
Have you prayed for interim order?
Yes, my lord, similar, my lord, only one thing, my lord, oita kothay de. A similar issue, my lord, I have the occasion to appear, my lord, cropped up with the railways. This honorable court in a separate writ petition, my learned friend was also there, my lord, he is aware. Now, my lord, this issue was entertained and there was an interim order and affidavits were directed. এটা মনে আইসি
এটা আমি ছিলাম না
তুমি ছিলে
দিতে বলেছিল তো দিতে বলেছিল তো is from initiating appropriate proceedings in due process of recovery of that claim.
Yes. Where is the document?
Yes, my lord, kindly takes up, my lord, page 83. What is that? দাদাকে একটা কপি জেরক্স করে দিই। তাহলে Maharaj got page 83, my lord. My lord, I do not trouble with the entire order, but my lord, the relevant portion upon which the authorities, my lord, issues the notice, my lord. My lord, kindly takes up from bottom the third last paragraph. If the appellant, Maharaj got that?
Yes.
If the appellant wants to continue with the hoarding, they would have to pay for it. We direct the appellant to pay rupees 70 on account without prejudice to their rights and contentions in this appeal. So, my lord, this was a condition. If I want to continue with the business, I have to pay it.
Yes.
Now, my lord, kindly takes up now, my lord, page 85. My lord, order is dated, my lord, 15th of July 2014. My lord, on November, my lord, I write a letter that even after the order passed in FMAT, my lord, I am not allowed to continue with the business, that I do not wish to continue.
Now, with regard to this 70 lakhs,
yes,
which this court has an order,
yes,
that is with regard to only if you continue or pending due.
No, my lord, they come and say, my lord,
70 lakh, how this 70 lakh has come?
The dispute in the suit was with regard to whether I am entitled to pay the enhanced rate of rent or, my lord, at the rate contractually agreed upon. Now, my lord, in that dispute, they file, my lord, a sheet where they say if the enhanced rate is to be paid, then I have to pay the preceding paragraph, my lord will find Mr. Ashok Chakraborty places relies on a sheet of 1.16 crore. Now, my lord, to that, the court says, if I want to continue the business, then ad hoc you pay 70 lakhs and continue till the dispute is resolved. Now, my lord, after that, my lord, I say that I do not wish to continue the business. And the
that is the only question here.
Yes.
The appellant wants to continue with the hoarding, they would pay
for it.
Have to pay for it.
Yes.
We direct the appellant to pay 70 lakhs on the account of without prejudice to the
So, therefore, my lord, it's on condition that if I want to
Yes.
run the business, then I have to pay.
Then,
Then, my lord, I say I do not wish to run the business.
When you stated
10th of November 2014, page 85, as they were not allowing me to do the business.
I have decided to stop my business Yes. Then
my lord, suddenly, kindly turns to page 94. Now, this is in vernacular.
yes. Not the translated copy.
My lord, this ought to have been translated, but my lord,
Then
my lord, I can only show my lord the 70 lakhs, my lord, find in my lord the first line.
what is this? This is an order.
No, this is a certificate notice by the officer, certificate officer, that you pay this 70 lakhs government dues. My lord has found that.
Yes, yes.
So, my lord, content is that you pay this 70 lakhs because this is a certificate due and under the act.
Yes.
Now, my lord, for some time, my lord, I participate in the proceeding, my lord. Thereafter, my lord, kindly turns to page 114.
Yes.
My lord, I come up before this Honorable High Court, challenging the jurisdiction and authority. Now, my lord, kindly turns the relevant portion. My lord, I am not taking troubling, my lord, with the arguments and submissions made. Kindly takes up from page 118.
Yes.
Not a Dubar annex. My lord, in view of the proceedings, my lord, 101st line, at the same time, it needs to be recorded that specific point has been agitated before this court with regard to the jurisdiction of the certificate officer to pass order in the proceeding initiated under the said Act 1913. An argument has been advanced on behalf of the petitioner. The demand raised by the Eastern Railway to the extent of 70 lakh is not to be treated as public demand, being defined under Section 36 of the said Act 1913. In view of the proceeding, which has been initiated before the certificate officer in 2006, this court at this stage is not inclined to interfere with such proceeding, but the petitioner is granted leave to take point of jurisdiction of the certificate officer in the pending proceeding by filing a petition within such and such date, and on receipt of such petition, the certificate officer shall make an endeavor to conclude the said proceeding as expeditiously as possible, but not later than 3 months from the date of filing of the petition by the writ petitioner. However, it is made clear if no petition is filed in terms of the leave granted by this court, certificate official shall take decision in accordance with law. Till the decision is taken by the certificate officer, no coercive steps shall be taken against the petitioner. With the aforesaid observations and directions, my lord, it was disposed of.
Yes.
So, my lord, after this order, my lord, I filed the petition, my lord, taking all these points, page 121, within that 30 days.
Yes.
Now, my lord, certificate officer passes the order which is under challenge. Kindly directly comes to the order. But that is at page last 228. I am not traveling, it records facts. First page, kindly takes up, in my respectful humble submission, the only paragraph, after recording all submissions by the parties, the only paragraph is the second last paragraph, is the, if I may put it in that way, that an order is passed absolutely without any reason. Kindly takes up in this circumstances. In this circumstances, after considering the submission of both parties as directed by Honorable High Court, Calcutta in WPS such and such, undersigned is of the view that the demand of 70 lakhs raised by railway authorities to be treated as public demand that is related to government use. End. Whether it falls under 3.6, under which schedule, nothing. Is it as if I file an injunction application and court says, plaintiff has a prima facie case, therefore I grant an injunction. My lord has held in penultimate decisions that this type of statement in an order is not a reason. It's a quoting of provision.
Yes.
So, he writes, I have heard, and this is government due.
Yes.
So, this is absolutely unreasoned prima facie. Now, second paragraph also, if my lord sees after that paragraph, this is also to add that the direction of Honorable High Court Calcutta to pay rupees 70 lakhs was challenged by the certificate debtor company and filed one SLP such and such dismissed. Hence, after considering all aspects, this forum was viewed that rupees 70 lakhs for which the instant certificate case being number 7 has been initiated a public demand as defined in the Act 1913, and the certificate of demand raised by the railway is right, and certificate debtor company is directed to pay 70 lakhs in favor of the certificate holder within 1 month.
Yes.
So, my lord, no reason anywhere. Now, my lord, kindly takes up the act. Prima facie, why I say, first, the order is conditional.
Yes.
Second is, my lord, under the Act. My lord, kindly take up section 36.
Yes.
Public demand means any area or money mentioned or referred in Schedule 1 and includes any interest which may, by law, be chargeable thereto, or up to the date on which a certificate is signed under Part 2.
Where is the Schedule 1?
Yes, my lord, take your lordship to Schedule 1, but before taking my lord to schedule, kindly take up section 4. What is the duty of the certificate officer? When the certificate officer is satisfied that any public demand payable to the collector is due, he may sign a certificate in prescribed form stating that the demand is due and shall cause the certificate to be filed in his office. So therefore, my lord, certificate officer has to come to and funding. This is a public demand. Now, my lord, kindly takes up Schedule 1, my lord, that is in this book, page 40. My lord will find the index, my lord, last Schedule 1 is paginated. You know, in that book, I don't know it's page 40 or not, my lord.
Yes, Schedule 1, public demand.
Public demand.
Yes.
Now, my lord, in my respectful humble submission, in from 1 to all this, my lord, which are the, my lord, given, my lord, are land revenue. If my lord looks into, my lord, land revenue, my lord, under the Act which says that it will be a public demand, but only provision, my lord, in my respectful humble submission, where, my lord, my learned friend on the other side, my lord, may come and say, kindly looks to this clause 18 of Schedule 1.
Yes.
18 is any money payable to government company, wholly owned either by the state government or by the central government, or jointly the state government and the central government. My lord, railway is not a government company.
Railway is not a
government company. Railway is ministry. Kindly takes up the impugned order. It is their submission. It's not a company, it's a ministry. There is a distinction between a ministry and a government company.
Under the ministry, if the department is under the ministry, it is not called a government department.
No. My lord, government company is a company, my lord, under the Companies Act, it's defined what's a government company. My lord, under the Railways Act, if my lord sees, my lord, the definition. This is section 2, subsection 20. Government railway means railway owned by central government.
Government railway. Government railway means the owned by central government.
So, my lord, it's a ministry. It's a department.
Means the railway owned by the central government.
Yes.
That's why the railway is under the central government.
Central government, absolutely.
There is
So, my
no
lord,
denial on that.
there is no denial
on that.
So, my lord, it's not a government company. And in my respectful humble submission, my lord, the public demands officer, my lord, the certificate officer ought to have gone into that question.
Okay. Yes, sir. What is your answer?
My lord, they will not pay the amount. They have taken the, my lord, service. Your lordship, if kindly see, several of time to time they have filed read petitions,
Now,
several
whatever
read
it
petitions.
is, now the question
And,
is that
and
your
my
office,
lord, my lord,
your
1
office-
minute, 1 minute, my lord. This application should be, my lord, rejected at once, my lord, due to suppression of the fact. The they have challenged the certificate officers whether he can be able to his jurisdiction, my lord, up to Supreme Court. That application has been, my lord, SLP was rejected, my lord. They have not mentioned here also in application.
But probably, my
And
lord,
your
this is
lordship,
from the
your lordship,
FMAT, we have gone to Supreme Court.
Your lordship, kindly see the order.
That is also reflected in the order itself.
Page 114, last order of the honor of this honorable High Court.
Page number?
Page 114.
114.
That says up to
114.
Supreme Court is FMAT.
That is the order dated 7th May 2020.
Yes, where, my lord, I was delegated.
Yes.
Your lordship, kindly see page 15. 115.
Yes.
Last paragraph.
Yes.
Learned advocate representing the Eastern Railway at the threshold has brought to the notice of the court the order of the Honorable Supreme Court dated 15th May 2015 passed on SLP being C as such and such number, which was preferred against the aforesaid order of the Honorable Division Bench. That is also challenged, my lord. According to the Eastern Railway, since the special leave petition was dismissed by the order dated 5th May 2015, there is no impediment so far as to certificate officer is concerned to initiate proceedings under the said Act 1990. They have nothing written in this application, my lord, not annexed, my lord, this order, my lord.
No, but when you mention this order before this court, coordinate bench of this court, but this court has directed your authority to dispose if you file an
My lord,
application.
yes, my lord, they have finally, my lord.
Correct.
So, jurisdiction, in respect of jurisdiction, my lord, the certificate officer has the jurisdiction.
No,
And it is
whatever it may be, now in terms of this order, he filed within 30 days, he filed an application before the concerned authority, and concerned authority has now passed an order.
My
He
lord.
has now he has challenged that order.
He has
So that
challenged that.
order has to be
He
tested.
in each and every, my lord, writ petition, he has challenged that this is not
Correct.
public
No,
money,
no.
and certificate officer has no
Now
jurisdiction.
this order is to be, this application, the writ petition is to be heard on merit after the exchange of affidavits. If
Yes,
he says
my
that he will not
They
file
will file affidavit, my
he
lord.
will file affidavit.
Yes,
So by that time, let the kept in abeyance.
my lord. It will be better, my lord, to file affidavit.
The petitioner has filed the present writ application challenging the order passed by
the
certificate officer.
Yes, my
It's
lord.
the certificate officer.
Last page.
Certificate officer 24 South 24 Parganas, Alipu. Dated. What is the date?
17/12/2024.
Dated 17th December 2024, wherein the petition is directed. To wherein the certificate officer held that the demand of 70 lakh raised by the railway authority is to treated as public demand as it is related to the government dues. Learned counsel for the petitioner submits that the certificate officer has not given any reason as to why the demand of rupees 70 lakh raised by the railway authority is to be treated as a public demand. He draw the attention of this court to the order passed by this court in WPA number 10805 of 2024, dated 7th May 2024, wherein this court has granted liberty to the petitioner to file an application before the certificate officer within 30 days, and the certificate officer is directed to conclude the proceeding as expeditiously as possible, but not later than 3 months from the date of filing of the petition by the petitioner. The petitioner has filed the petition as per the leave granted by this court by an order dated 7th May 2024, and has passed the impugned order. This court also find that though the certificate officer has held that the demand of rupees 70 lakhs raised by the railway authority is to be treated as public demand as it is related to the government dues, but this court is of the prima facie view that the finding of the certificate officer is without any reason. Full stop. Learned counsel for the respondent press for time to file affidavit in opposition. Let affidavit in opposition be filed by
after vacation, my lord.
Filed within 2 weeks after puja vacation. Reply, if any, there to be filed within a week thereafter. List the matter on on 27th of November 2025. In the meantime, the respondent authorities, particularly the respondent number,
Respondent number, certificate officer, it's
respondent number 4 is directed not to give any effect or further effect till 27th of November 2025 or until further order, whichever is earlier.
The affidavit of service we kept on record.
Affidavit of service filed by the petitioner be kept with the record.
On every occasion, my lord, they have submitted the same thing, my lord.
Now this will be decided.
My
lord, because what all government dues are not public demand. Otherwise, in tender matters also.
That's why let them file the affidavit. It will decide on merit once for all.
Absolutely.
My lord.
My lord, only thing, my lord, may I take back the book? May I take back the book, my lord, which are.
Yes.
157, my lord, I am appearing on behalf of the Lordship Information Commission. My lord, have taken up 157 of the out of turn. My lord. May I appearing in this?
Give the name.
May I give?
Give the name. Record his name in the 157 dispose of. No? Yes, call the matter.
That's my
Item number? Yes.
This matter I have filed my lord, challenging the appointment of my lord, public prosecutor. My lord. In name,
What is the ground challenging the appointment of public prosecutor?
in fact, my lord, our High Court my lord, has removed by an order, previous order. My lord, if you will kindly take some page 13, there's an order of Honorable High Court of this High Court.
Under the POXO Court, under the for the POXO Court, public prosecutor is special public prosecutor.
He is now acting as a special public prosecutor.
That's why.
Now, page 13 is the order passed by the division bench of our High Court. But if you kindly takes up page 14, paragraph 3 and 4. At paragraph 4, court has recorded explanation offered by the public prosecutor in charge of the case shows a patent lack of application of mind to the facts of the case. It is dangerous that the person of such indifferent and callous attitude are in the panel of public prosecutor. Accordingly, we direct the legal administrator to remove the public prosecutor in charge from the panel. Now, this was the remarks, my lord. Now, my lord, they challenge this order in before the Supreme Court, my lord, in SLP. That page 17 is the relevant part. Court has considered the observation of the court
Submission of the state.
and considering the submission of the state, page 17, second paragraph, Learned Counsel for the state submits that in pursuance of the order of High Court, the name of the petitioner has been removed from the panel. Therefore, nothing further needs to be said or direction has been complied with.
Correct.
Then, court has observed that since the name of the petitioner has already been removed from the panel, we need not say any further. However, remarks of the learned judge in the impugned order shall not be read against the petitioner in future engagement. But immediately he has been engaged. Now, in 2025, Supreme Court passed a judgment in regard to the appointment of public prosecutor, as well as in 2023, judgment about.
Have you served?
Yes, I have served.
Who is the public prosecutor? He has been made as a party.
Public prosecutor made a party.
Yes,
Legal. Yes, Amit. Service affected.
Now let me check once. Delivered. Yes, delivered.
You are appearing for? Not for to the public prosecutor.
And yes. I have annexed and complaint of other public prosecutor where they have made a specific allegation of bias, corruption by the other members of the same panel against this man. Page 18.
But that letter has been made in 2023.
Yes, no doubt. But these are serious allegations against the judgment.
Yes. Which judgment you are relying upon?
to bring action. That may be permission. Huh. But I'm just reading with the relevant paragraph only. And if you actually kindly take some let paragraph 91 onwards. The public prosecutor, instead of assisting the learned judge in the right direction by pointing out the correct position of law, went to the extent of praying before the court that the appellants herein deserve capital punishment. This was the context. Then paragraph 92, such is the standard of the public prosecutor in the high courts of the country. This is bound to happen when the state governments across the country appoints AGPs and APPs in their respective high courts solely on political consideration. Favoritism and nepotism is one of the additional factors for compromising merits. The judgment is a message to all state governments, and the AGPs and the APPs in the respective high courts should be appointed solely on merit of the person. The state government owes a duty to ascertain the ability of the person. Proficient person is in law, the overall background, his integrity, etc. Time and again, this court has observed in so many of its decisions that such appointments, be it high court or in the district judiciary, should be only taking into consideration the merit of the candidate, and no other consideration should weigh in such appointment. Public prosecutor holds public office. The primacy given to him under the scheme of CRPC has a special purpose. Certain professional official obligations and privileges are attached to this office. His office may also be termed as an office of profit, as he remains disqualified to contest the election so long he holds the office, though permanency is attached to the office and not to the term of his office. His duties and public nature has an independent and responsible character. He holds the public office within the scope of coherent proceedings. Prosecutor is not a part of investigating agency, but is an independent statutory authority.
Now the other side is not appearing.
So far, a POXO case is concerned, there is a judgment of 2020, where court has held that everybody should be trained, and in absence of training, they are not qualified to listen 2020. Must knowing of the judgment. This is of 2020 7 SCC page 130.
Correct.
And it directs all states to hold training.
Yes, now time to time the government is also conducting the training. Now I think still now training is going.
Should be against this person, court has observed that he is not fit to be a public prosecutor. Immediately he has been appointed because of political consideration.
But how the court can now interfere at this stage? Let they file affidavit.
But in the meantime, he should not be allowed to one more order. You are Chief of Public Prosecution.
One submission.
I will come. Only to this extent, I'll be requesting your lordship to interfere. He is acting as a chief PP. Third paragraph. Yes, from first order, from the second last paragraph, the PP in charge of the Kakdeep, namely Amitabh is present in court. He should not at least act as a PP in charge in the meantime.
No, what has happened in the district courts, if you are the PP or you are they write the PP in charge, this is the routine.
I am saying this because kindly see page 18. Page 18 of my petition. This page 19, the signatories are all PPs of that court. They have made allegation against this man, saying that he is holding all serious matters, and he is holding POXO cases, and there are allegations I do not utter. These allegations are there against this man. These are lawyers. They are making complaint against this man.
Yes.
My one submission is this petitioner has not submitted any written complaint against this Amitabh today, till now.
Who are you?
I am the a member of the bar.
No representation.
If you are the member of the bar, how it can be?
I am the member of that bar as well as this bar.
Might be, but how you can challenge this?
Kindly see the sixth name.
You are not the aggrieved person.
And who is the petitioner herein?
That here, blood, I am always, since it's a post of public post and court has held that even quorum is maintainable. Therefore, blood, anybody can challenge if the person doesn't have the qualification.
It is not the case. He's not having the qualification.
Yes, blood.
You see, your only contention is behavior was not good. Earlier, it was removed. Now, after the order, again he has been appointed.
Blood, if I am not mistaken, blood, court has held blood that he is callous.
Correct, but the Supreme Court has clarified it cannot be taken into consideration in his future engagement.
Because of submission, they said that he has been removed. That is,
but he has been removed. Then, since the name of the petition already removed from the panel, we need not to say anything. However, the remarks of the learned judge in the impugned order shall not be read against the petition in future engagement.
Future appointment. This order was passed on 20th September, and when the appointment was made, immediately.
October.
28/10/2024. An order?
Well, immediately, 20th August, October.
After 1 month.
9th September and October.
After 1
immediately, please.
Okay, let the file affidavit. Let the file affidavit. The petitioner has challenged the order of appointment of the private respondent as penal public prosecutor. Penal public prosecutor. This court is of the view that this application is to be disposed of after exchange of affidavits. Let affidavit in opposition be filed by
state.
Yes. You have to give the answer. How much time? 1 week.
After vacation.
2 weeks after puja vacation. Reply, if any, there to be filed within a week thereafter. Please the matter on 27th November 2025.
In the meantime, whether she should act as chief or.
एक मिनट वो वाला order तो ऊपर वाला copy. Learned counsel for the petitioner has handed over the copy of the order passed by the Additional Sessions Judge, First Court, and Special Court under POCSO Act, Kagdeep, South 24 Pargana, dated बोला ऊपर, in special POCSO case number 29 of 2025, wherein the learned judge, POCSO case number 29 of 2025, wherein the learned judge has described the private respondent as PP in charge of Kagdeep Court. This court made it clear that the private respondent has been only appointed by a notification as penal public prosecutor. He can act only as penal public prosecutor until grateful.
Number 4.
Act only as a penal public prosecutor without any further order from the government. Yes.
But it is a petitioners are teacher of the National Child Labor Project scheme. It is sponsored by the central government and implemented through the state of West Bengal. And in this case is from District Magistrate Howrah. They have not paid 42 months remuneration. 42 months.
Where is your engagement order?
Yes, my lord. Your lordship finds it at page 11. 11. It is a engaged through NGO, my lord.
Through NGO?
Yes.
So who will pay the payment to you?
District magistrate. That was the reference. Sorry.
How if you have been engaged to the NGO, how the magistrate directly pay to you?
Yes, they're paying, sir. My lord, you lordship kindly come to page 39, my lord.
39?
39. There is a reply from the project authority.
39?
39, yes.
Your petition contained only 37 pages, sir.
39, my lord.
We got 39 pages, my lord. We got the 39.
You got the 39. But this code is having only 37. This is the WPA number 6519.
কোর্টের কাছে নেই এটা দিয়ে দিন তাহলে
WPA number 6519. Mohanta Mahakal.
Yes.
Yes.
My lord.
May I give it to you, my lord? May I give
Just a minute. No, 36, 37. Last 37. Order dated 18/11/2024. See.
Oh, marking this is 7. Pagination is wrong. I'm apologizing. My lord, before
I will hear all persons. Don't worry.
Your lordship find that
Yes.
they replied to me, the petitioner, that their case is pending and their dues is pending and
Reply to the petition. National Child Labor Commission was closed by night. No staffs are engaged and posted in Auna and CLP. Until this last staff was area in last due. Yes. So from which date to which date you are claiming the remuneration?
Your lordship kindly come to page 30, my lord. 30. District Magistrate write a letter to the Undersecretary Government of India.
30.
30, my lord.
That's okay. Again your pagination is problem.
Dated 23rd 11/2022.
Dated 23rd
11/22, my lord.
Yes. District Magistrate letter.
Yes. There is a outstanding dues of my lord. 1 crore 94 lakhs.
1 crore 94 lakh 61,750.
Yes. There are several people are there. They are admitted, and actually it is originated from page 23, my lord. Actually, central government and the scheme, they write a letter all the district magistrate.
So that's why you are claiming remuneration. You are claiming.
Yes.
From which month to which month or which year to which year? Where is your claim?
Yes. My lord.
Where is your claim?
Yes, my lord.
Where is your representation? Which year to which year you have worked and you have not been paid? So that is to be tallied with the page number 39. Where is the representation?
My lord, individual representation was not taken, my lord. My lord, at page 30 it is clarified, my lord. It is subject liabilities claim financial year.
That is liabilities, okay. That is the government to government. That's the inter department.
My submission is that all these NGO are manning it. NGOs are manning it.
That's correct, sir. First, you have to ascertain what is your claim. You have not made any claim. Where is your representation?
I have made claim. That's why
Where is your representation?
No representation is there, my lord.
Where is the representation? This is not a public interest litigation, sir. It is your claim. Your claim, you have to establish your claim. Yes, I had worked so and so date to so and so date. I submitted the representation. Authority not consider. Where is that? You are relying upon the internal document of the departments.
But that is divulged by the
and the state government, the NCLP has already stated that NCLP has been closed.
Closed or not?
Petition is not maintained even according to the law.
Yes.
Petition is not maintained even according to the law.
Why?
Procedure code section 80, it is very much clear that the petitioner issued the notice before filing any case, and appellate side rule 53 civil procedure code follows. Then at first proved that he issue the notice to the
That's why
government.
the court is
Any
asking.
representation.
That's
is
why
the main point of
that's why
saying.
the court is asking the question. Why
That is the
court
point.
is asking the question?
No representation, no notice.
Where is your
My
claim?
humble
How
submission
can it
is
possible
that
to read
my
petition?
humble submission is that we are recruited through NGO. We are not directly related, my lord.
So we were not directed with the NGO. How the department is bound by your duty? You claim you have been engaged by the NGO.
Yes, I am
Correct.
the NGO.
And NGO has to pay the amount to you in terms of the minimum wages act.
But they are paid by the central government through
Central government is not paying directly to you. Central government is giving some scheme or some whatever the amount, whatever it is to the NGOs.
Yes.
Then NGO is disbursing the said amount to you.
Yes, my lord. Or to the
So
notice at
how
first.
because if it directly paid to you, that tomorrow you will come for regularization. If the government directly pay the amount to you, then tomorrow after the 240 days you will come for the direct regularization.
I have made the NGO party.
NGO might be party, but your claim how this court can decide.
My lord, more so, my lord, in respect of.
I am dismissing this with the liberty to claim make appropriate application before the authority.
My lord, I'm withdrawing it. My lord, I'm doing it. Withdrawing it.
If you are making the claim against the NGO, whether the writ court can decide the private dispute.
That is the main point of thing, my lord.
That is made him a party, but the state,
State is not paying directly to you.
But the constitution
Then this is the repetition, man.
I'm withdrawing with you.
Counsel for the petition.
Leave to refiling. Leave to refiling.
Counsel for the petitioner, press for withdrawal of the suit. Put with the liberty to file a press if any occasion arises. In view of the a press if any occasion arises. In view of the submission made by the counsel for the petitioner, WPA 6519 of 2025 is dismissed as withdrawn with the liberty to file a press if any occasion arises. Next.
তোমাদের নাম দিয়েছো?
None appears on behalf of either of the parties. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter go out of the list.
Item number 3. But I am for the state respondent.
Yes. You are for the state respondent. Who is for the petitioner?
Mr. Shumon Shah. It's a tender of 20.
Remit the amount of outstanding due. The money suit.
Tendered amount 2020. Work extended till 2021. They file this writ application for recovery of that amount 2025 without explaining any details.
Admitted. You admitted the claim. Nobody is there. Let's go out of the list. So appearing for the state respondents. None appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list.
With liberty to mention after giving notice.
Huh? Liberty to no. They will mention that automatically it will come.
Great.
Item number 7.
I appear for the petitioner, my lord. It's a matter where, my lord, the petitioner father had instituted a suit in the year, my lord, 1991.
Petitioner father.
Yes, my lord.
Instituted suit.
Yes.
Then
under section 8 and 9 of the West Bengal Land Reforms Act. An order was passed in my favor. It was appealed against. In appeal, my lord, the order of the learned trial judge was set aside, which forced me to come to this court in a revisional application. Now, my lord, the order was passed, setting aside the order passed in the appeal, directing, my lord, the learned trial judge or the the appellate judge, my lord, in the lower forum, my lord, to expedite the suit. But the difficulty today, my lord, which has, my lord, prompted the petitioner to approach your lordship is that the entire file is untraceable. But we had made representation.
So what is the prayer here?
Prayer is direction upon the London district registrar or the district judge to give a directions upon the authorities to trace out the file. Because if your lordship kindly comes to page 16.
This you have written here. What is the suit for? Now it is suit is pending.
Suit is
after
pending.
remand.
After remand.
By the revisional court and the appellate court.
Yes.
It is remand before the trial court and both the
Remand
parties.
the appellate court.
Remand before the appellate court.
Yes.
Revisional court has remanded to the appellate court for reconsideration.
Yes.
And you are benefited with the decree by the trial court.
Yes.
So on the with the appellate court, the appellate record is not available.
Missing.
Since what was the last date it was fixed before the London appellate court?
But as the file is missing, my lord,
the last date, last order of the trial of the appellate court.
But the put up petition was moved, my lord. If your lordship kindly comes to page 21.
Page
21, my lord. We had brought
additional district judge, district and session judge.
we had brought into the notice.
Haldia.
Yes, madam.
9/9/2019.
Yes, lordship. Well, kindly see the order passed by this court, my lord. It was on, my lord.
This court also passed an order.
Yes.
What order?
Kindly comes to page 14, my lord. Kindly 16th of August 2019, the order was.
That is on revision.
Yes. And we had by that petition at 20.
Achha, this order has been made
Yes,
put up application
yes,
before
yes,
the court.
Yes.
But since then they are not
Nothing,
taking.
no development.
Which court it is? Haldia.
Haldia, madam.
Huh?
Haldia, London Additional District and Session Judge, fast track Haldia.
Haldia. It is Purbi Medinipur.
Purba Medinipur. I should be also be candid before your lordship. But the affidavit of service we had served, they had received, it has been lost. I would be praying before your lordship a leave to file and affirm afresh affidavit of service.
Now then who has been made party?
Well, the party here in my lord is
district judge.
And the registrar also, my lord.
Registrar London district judge.
There's a representation your lordship would be finding, my lord, at page 23, my lord.
So I am calling for the report from the district judge and the registrar.
Lord.
The petitioner has filed the present writ application praying for a direction for consideration of the prayer made by the petitioner before the to whom you have made the representation.
Lord, you would be finding at that
to the London district judge, Purba Medinipur, dated
the 17th of
17 February 2025. क्या बोला? Before the London district judge, Purba Medinipur. And to take appropriate decision. Fourth. London counsel appearing for the petitioner submits that initially the suit filed by the petitioner was decreed by the trial court. Being agreed with this decree, the respondent had preferred an appeal, and the appellate court set aside the order of the trial court. Being agreed with the order of the trial court, order of the appellate court, the petitioner had preferred a revisional application before the coordinate bench of this court, being CO number 4245 of 2007. Full stop. This court disposed of the said revisional application by an order dated 16th August 2019. 16th August 2019. By setting aside the order of the appellate court, and the appellate court is directed to decide the misappeal number 40 of 2006 afresh expeditiously. After the order passed by this court in the revisional application dated 16th August 2019, the petitioner has made a put-up application before the learned district judge, additional district judge, first and sessions judge, fast track, Aldia for disposal of the appeal in terms of the revisional application, in terms of the order passed by this court in the revisional application. The petitioner complains that since then the record of the appeal number 40 of 2006 is not traceable. The petitioner has made several requests, but till date the record has not been put up so that the appeal filed by the petitioner can be disposed of in terms of the order passed by this court dated 16th August 2019.
The appeal filed by the opposite parties, not us.
Revisional in terms of the order passed. Full stop. Considering the submission made by the counsel for the petitioner, this court is of the view, before passing any order in the present, before disposing of the present writ application, it would be proper that a report is to be called for from the learned district judge, Purva Medinipur, as well as the registrar, learned district judge, Purva Medinipur, with regard to a record of the appeal number 40 of 2006 pending before
the additional and fast track.
You're correct.
Yes, madam.
Pending before the additional district and sessions judge, fast track court, Haldia. Let this learned district judge, Purva Medinipur, as well as the registrar, the learned district judge, Purva Medinipur, are directed to file the report before this court why the record of Miss Appeal number 40 of 2006 has not been put up and disposed of in terms of the order passed by this court in civil divisional application number 4245 of 2007 dated 16th August 2019. Let the report be filed by 24th of November 2025. List the matter on 27th of November 2025.
We can also intimate this order to the respondent.
The petitioner is directed to communicate this order to the learned district judge as well as the as well as the registrar of the learned district judge forthwith for compliance of the order.
And to file a fresh affidavit of service on the next date.
Come.
I'm grateful, madam.
Next.
Thank you for the petition. Affidavit of service, madam.
Private appeal for the state respondent.
In this matter, my lord, the matter is short, my lord. The petitioner was running one security agency, and my lord, the state being the respondent number 3, my lord, Alipurduar National Highway Authority, issued a floating a tender process, and petitioner participated in the tender, my lord, and he got the tender, and my lord, the tender end in the year 2021 March. From that time, my lord, there is a earnest money is deposited 25,000, and my lord, his due was 1,26,000. Total 1,53,000 not paid to the petitioner, my lord. He made several representations, more than 12, my lord, from 2021, my lord. But the concerned authority, nothing from the authority also. This is the grievance, only grievance this. His earnest money and my lord, the last bill.
What has happened to your tender?
That is end in 2021.
Complete executed. completed, but that the PG and the security has not been released.
No, man. But first of all, the contract ended in 2021. He is approaching this court in 2025.
No,
Yes.
This is a money claim. Your lordship knows better than me, my lord. Money
This
claim.
court don't know anything. You have to teach us.
That period is over. I am 76 now. Money claim, my lord. At best, his representation may be considered by the executive engineer.
So you wanted to alive his delayed claim.
Well, my submission would be this.
You are making a submission. This claim is barred by limitation. Now you are telling that the representation be considered.
I'm now
Then the new cause of action will arise.
I am now deducting that part.
Automatically, if the court will pass an order for consideration, then you will pass an order.
And then
denying the claim of the petitioner.
And fresh cause of action will arise. My lord, kindly seize, my lord. Work order is of 2019.
Yes, what you have done?
My lord, from page 36, my lord, every 3 months, my lord, he made representation.
Every 3, making a representation will continue the cause, the limitation.
My lord, they are saying that from every time, from
when your work was ended.
21, my lord.
21, then your 24, your claim is barred.
But from 21, he is making representation.
Huh?
From 21.
21, you made representation.
21,
Even in the so moto order will not cover because March 2022.
21, 22, 23, 24. Every year.
When you file this writ application.
Last representation, my lord.
No, when you file this writ petition.
March 25, my lord.
Then again it is if
representation
if you go by the Supreme Court order also, February 2022 is the last.
But my lord, here there is, my lord, he making representation. The authorities.
Yes, he will consider.
This is a very bad case. Really very bad case.
You have a judgment of the Somoto of the Supreme Court during this.
I know that, my lord.
So what is the last date of the Supreme Court judgment?
February 2022.
Huh?
28 February 2022.
28 February
2022.
22 then.
Well, but in this case, my lord, the petitioner authority is sitting tight about the matter from 2021.
You are also sitting tight.
Petitioner making from page.
Why you not went to the court or authority or anybody? After 25, how this court can allow this?
From 36 page, my lord, we are making so much representation. More than
making a representation will say the delay can be condoned.
This is the papers available. He is depositing, my lord, earnest money, that is also not given. Earnest money page 32 onwards, my lord. The earnest money is also not returned to him. Page 33, 34, that is earnest money. He is deposited.
Yes, why you not release? Maybe delay. Why you not release? Security amount, it is right.
To that extent, my lord will kindly pass an order to the executive engineer.
The petitioner has filed the present writ application, praying for a direction upon the respondent number 3 for release of the payment of wages.
Yes, my lord. Security 1 month wages, my lord.
He was contractor. He was engaging persons.
Security service person.
You are telling that security service?
The wages of the, my lord, the persons who is engaged by the petitioners. Petitioner security.
So you have submitted the bill. They are not raised.
No.
No. No, that is the barred by limitation.
Earnest money, my lord, is not given.
That barred by limitation. You have submitted the bill on 2021 and 25 you are coming to the court. That is a bar. Yes, what you will do? Shall I dismiss on merit? What do you want to do?
Can you pass on?
Pass on. The petitioner has filed the present application, praying for a direction upon the respondent number 3 for release of payment of wages amounting to rupees 1,53,921 in connection with the deployment of security guards by the petitioner to the authorities to the authority. This is the only claim.
Only claim.
The counsel for the petitioner submit that time and again the petitioner has made several representations since the month of March 2021 till September 2024. In spite of the receipt of the representation, neither the respondents have denied the claim of the petitioner nor have released the said amount. Full stop. He further submit that the last representation was made by the petitioner on 13th of September 2024 and the same is pending before the authority, and he prays for a direction upon the authorities, that is the executing authorities, for consideration of the representation and for release of the amount due. Full stop. Per contra, learned advocate appearing for the state respondents.
Lordship, my lord.
State respondents submit that the work was completed in the year 2021 and the petitioner has filed the present application for claiming the said amount in the year 2025. That is after the limitation period of 3 years. He submits that the claim made by the petitioner
is in respect of March 2021.
March bola hai na? In the month of March 2021. He submits that the writ petition filed by the petitioner is barred by limitation, and as such, the same is liable to be dismissed. Had the learned counsel for the respective parties peruse the materials on record. This court find that the petitioner was awarded the tender by the executive engineer,
yes,
by the respondent number 3 for supply for deployment of security guards in different establishment. As per the tender, as per the work order issued by the executive engineer, the petitioner has issued by the executive engineer, the petitioner has deployed security guards from time to time and raised the bills with regard to the wages of the security guard deployed by the petitioner. He submits that an amount an amount of rupees 1,53,921 is due and pending against the respondent authorities, but the same has not been paid. This court finds that the tender was completed on 8th of March 2021. Subsequently, though the petitioners have made several representations, but has not approached before this court within the limitation period of 3 years. Now, after the period of 4 years, more than 4 years, the petitioner has filed the present application. Considering the above, this court finds that the writ application filed by the petitioner is barred by limitation. Accordingly, the same is dismissed.
My lord has left us, my lord. That building, it's very difficult to run and come and join.
Service may be kept with them.
Affidavit of service filed by the petitioner be kept with the record.
Deeply obliged, my lord.
Yes.
My lord has left that building. It become very difficult to run and come.
None appears on behalf of either of the parties. No accommodation is sought for. Let the matter go out of the list.
Item number 10.
My lord, for item number 10, Advocate Anona Niyogi is appearing for
You are appearing for?
For the state, my lord. Advocate Anona Niyogi is appearing. My lord, she had to leave court after recess due to illness. I'm praying for not this week.
Who is for the petitioner?
Lordship, I am for the petition.
Yes, what is the claim?
Lordship, this is a short matter regarding compassionate appointment.
Compassionate appointment. In which department?
Department of Youth Services and Sports.
When who died? Father?
Father died.
When died?
Died on Father demise took place on 10th September 2024.
24.
Yes. And we made the representation.
What your father was doing?
He's a upper
division clerk.
upper division attendant.
Upper division attendant. Yes. Who are you?
I'm the elder son of the
Elder son. What is your age?
Age is around 30. Lordship.
30. So how many dependent members are there?
3 members.
Huh?
My mother, me, and my brother. We have annexed the NOCs.
What is your income?
Lordship, I am unemployed right now.
You are unemployed. Your brother?
Brother is also unemployed.
Unemployed. Mother?
Unemployed.
Any landed property? Any landed property?
No, Lordship.
No landed property. Died in harness.
Probably due to COVID.
COVID? 2024 you are telling us how the
Probably
COVID?
it's because of illness. That's what we have been instructed.
Where is the death certificate?
Death certificate is annexure at page number 12.
Page number?
12.
September 2024. 58 years. 58 years, 2 years. What was the age of retirement? 58 or 60?
Well, Lordship, 25 years. He only rendered service for 25 years, Lordship. If
Maybe, but
1999 is the
maybe, but the age of retirement is 60 or 58. Which department? Yes, madam, you know. Age of retirement 60 or 58.
Madam, I'm not aware of the age,
You're not
but
aware
the
of that.
department is Department of Youths.
When you made the representation?
We have made the representation, Lordship, on 24/10/2024. Almost 1 month later.
After 1 month?
Yeah, 1 month, 14 days.
They are not considered.
No, Lordship.
Where is the representation?
Representation is reflected in
page 19,
page 19.
19.
In Bengali.
Any reply?
No reply. No communication. Nothing.
Consider it.
My lord, shall we file a report, my lord?
What report? I am disposing of. Consider and pass appropriate order, giving an opportunity if required. Correct. The petitioner complains that the father of the petitioner was working as lower division attendant.
Upper divisional attendant. He got promoted in course of his service.
Was working as upper division attendant in the Department of
Youth Services and Sports, Malda.
In the Department of Youth Services and Sports, West Bengal, Government of West Bengal. He submits that the father of the petitioner died in harness on 10th of September 2024, leaving behind his wife and 2 sons, out of which the petitioner is one of the sons.
Petitioner is the elder son.
Petitioner is the elder son. Kaushik Shah. What is the name of the petitioner?
Kaushik Shah.
Kaushik Shah. Elder son. He submits that the wife of the deceased father is a housewife and both the sons are also unemployed. Due to the death of the father, the family is in starvation. After the death of the father, the petitioner, being the elder son, has made a representation to the respondent number, to the office of the respondent number 2 for appointment, for compensation appointment on 24th October 2024 by disclosing all the relevant documents, but till date the representation has not been considered. This court find that the petitioner has made an application for compassionate appointment on account of the death of his father during his service. Thus, no purpose should be served by keeping the writ petition pending. Accordingly, WPA number 6644 of 2025 is disposed of by directing the respondent number 2, director of the service, that he will consider respondent number 2 or any of the competent authority to consider the representation filed by the petitioner dated 24th of October 2024 and to dispose of the same within a period of 6 weeks from the date of receipt of this order. Full stop. It is made full stop. As the respondents have not filed the affidavit in opposition, the allegation made therein be deemed to have been
Affidavit of service.
affidavit of service be kept with the record. Next.
My lord, Mr. Boshu Mollik appearing on behalf of the state respondent. My lord, he is engaged in courtroom number 16. My lord,
You are appearing for whom?
Yes, my lord, state.
You are appearing for whom?
My lord,
State.
I am not appearing in
You are
this
the
matter,
proxy
my
of
lord.
the state.
Yes,
You
my
are the proxy of the state.
proxy of the state. No, my lord.
Record and order. None appears on behalf of the writ petitioner. No accommodation is sought for. Let the matter go out of the list. Next.
Item number 12.
12, my lord.
Yes.
Lordship.
Talk to see.
After
the
a
appellate side.
lordship. After a long time, I got the privilege of addressing your lordship.
Yes.
Lord, today for the state in this matter,
Who
lordship.
is for the petitioner?
Lord, petitioner
Nobody.
Songjukta Shamanto, bar 15.
What is the prayer? What is the
Prayer, my lord, the petitioner is a scheduled tribe, scheduled caste. And my lord, she wants consideration of her representation, my lord, that is at page 24.
For?
That police have not taken any action on the complaint lodged by her. That is at page 24. So alleging inaction, my lord, she is before your lordship. But the issue is, prior to that, there was a writ petition preferred by her. That was disposed of, has been grossly suppressed in this writ petition. But my police report says that yes, it was. Police also, on the basis of this complaint, undertook a discreet inquiry, found that the dispute is purely civil by nature. Police have nothing to do in this issue. So if I may put this police report on record, lordship. An earlier order. In the fourth paragraph, kindly sees, my lord. After consulting the available PS record, it came to learn that over the said issue, the petitioner had filed one writ petition number 18751 before the Honorable High Court, Calcutta on 19 December 2024. Honorable Justice Titanka Ghosh passed order to the effect that in case the petitioner finds that further mining activities is being carried on, the petitioner will approach the DLLRO who had issued the closure notice. Such representation would be considered and further direction may be intimated to the police for taking necessary action. Now, my lord, next page it says a petition was received from Dalem Tudu, that is the petitioner before your lordship, which was addressed to the Superintendent of Police on 12th March 2025. This is the representation annexed at page, my lord, 24. Page 24. And what does the police say next? Kindly say, and the same was endorsed to SI so-and-so for Rampurhat PS for inquiry. During inquiry, the EO Shuken had been to the village of so-and-so, contacted the petitioner, some other disinterested respectable people locality, also visited the plot numbers in question,
recording ALR Khatiyan number so and so. After completion of inquiry, he submitted prosecution against alleged person, namely Milan Sheikh. That is the private respondent in this writ petition. So prosecution was, my lord, done on so and so, under section so and so. Now it is pertinent to mention that the issue is purely falls under jurisdiction so and so, so and so. My lord, this is the issue. So police have entered into an inquiry and found it's civil by nature. And now the order before this honorable court was that regarding this forcible grabbing of his property and undertaking the activities of quarry mining. So the order sheet in the earlier writ petition shows that be that as it may, the learned advocate appearing for the respondent number 11 has submitted a closure notice of the ADM LR, wherefrom it is reflected that the concerned authority has directed for respondent number 9 not to operate in a mining unit and served a closure unit. So far, my lord, so on one hand, torture that has been inquired into by the police, inquiry held. On the other hand, so far as mining activities part is concerned on his land, closure notice from the earlier order itself is clear. Closure notice was slapped, my lord, by the ADM. Lordship knows, me under the Minor Minerals Act, Trade with Concession Rules of 2016. ADMLR is the authority who is to deal with all these issues in the district. So, my lord, both sides, according to my understanding, it has been done.
Nobody is there. Record or not? None appears on behalf of the petitioner. So appearing for the state respondent and filed a report. Let the same be kept with the record. It is found that the grievance of the the grievance of the petitioner before this court for a direction upon the police authority for taking appropriate action on the complaint made by the petitioner to the officer in charge, Rampur Hat Police Station, Birbhum District, and the district magistrate of Birbhum District Police. This court find that this court considered the report submitted by the state respondent and find that on receipt of the complaint submitted by the petitioner, an inquiry was conducted, and after the inquiry, it was found that prosecution against the alleged persons, namely Milan Sheikh, son of Adel Sheikh of Bonhat, PS Rampurhat, District Birbhum, PS NCR number 663 of 2025, dated 23rd April 2025, under section 126/135 within bracket 3 of BNSS was initiated. As regard the other allegation made by the petitioner could not be substantiated. Full stop. The inquiry also reveals that the issue raised by the petitioner in the complaint is purely false false within the false as a civil in nature, and as such the police authority cannot resolve the same. Considering the report submitted by the in charge Rampurhat PS dated 30th April 2025, this court finds that nothing remains in the present writ application. Accordingly, the same is disposed of.
Grateful to lordship.
Item number 30.
Lordship, I appeared for the respondent number 2, Your Lordship.
Who is for the petitioner? What is the grievance?
Up for the first time. Your Lordship, the grievance is against, it is a building, Your Lordship, it's a
Ballot
society.
paper intending to reinstate the dismiss board.
Lordship, it is regarding an election conducted in the association of that society or housing society or Lordship. Now, what has happened? This writ petition
is
has
not
been.
there. Let it go out of the list.
Lordship, the writ is infructuous in itself because the writ has been filed after the election has been already over. And before that, this is the second round of litigation, Your Lordship. Before that, an administrator was appointed. Administrator had already handed over the charge. After that, this writ petition is being filed, and kindly looks at the prayers, Your Lordship, prayer G. They are praying
That
that.
side is not there. What? None. So appearing for the state respondent.
State.
You're for the state respondent.
No.
You're appearing for.
Appearing for respondent number 2, Your Lordship, the administrator.
Respondent number 2. None appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list. Yes.
Item number 14, Lordship, I appear for the respondent, Lordship.
All respondents are appearing, no petitioners.
This writ petition is not maintainable. They have challenged my action taken under Section 14 of the SURFACE Act, where I'm a finance company, Your Lordship. I'm not.
You are the finance company.
Yes, I'm not amenable to the jurisdiction of this honorable court. Your
So what they are asking for?
They're asking for setting aside of my order passed under Section 14 of the SURFACE Act. If they have any remedy available,
It
that
in the nature of directing district magistrate to cancel and quash the impugn order as well as the possession proceeding. District magistrate.
Yes, this
Possession notice.
Yes, Section 14 order passed for possession, physical possession, that has been challenged in a writ petition where they have a remedy for section under Section 17 of the SURFACE Act. It is not maintainable, Your Lordship. He's a loan defaulter. Now he has not paid money, and this writ petition is fine.
But other side is not.
It's not maintainable, Your
Maybe, but
as Your Lordship tunes.
Only it will be remanded.
As
No opportunity of hearing.
As Your Lordship.
The sense appearing for
the respondent finance company, IIFL Home Finance Company. For the respondent number 2 and 3, Your Lordship.
For the respondent number 2 and 3, none appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list. Next.
Number 15. My lord, I am appearing for respondent number 3, private respondent.
My lord, I appear for the petitioner. I am being led by Mr. Ranjan Bachawat. In item number 15 and 17, he is extremely unwell, my lord.
What is the matter about?
My lord, the writ is not itself maintainable. I can satisfy, my
I
lord.
have the papers right away, my lord.
My lord, it is a writ preferred against a insurance ombudsman award. My lord, a similar writ was filed in 2024 by the same parties, wherein there was a direction by this honorable court for the insurance ombudsman to consider the complaint and pass a recent award, my lord. My lord, the dispute which is before this writ court, my lord, whether a certain insurance policy issued by the private respondent can be considered as a digital policy or a non-digital policy. My lord, where is the infringement of fundamental rights? It's purely a contractual dispute. They should approach the civil court. And even the insurance ombudsman awards the same. In one occasion, my lord, if my lord takes up the item number 15, wherein
for time, what can
my lord will only grant us an accommodation
senior
for
is not
ready.
here.
my lord, I have.
If this court will pass an order, he will be in trouble.
Very
good.
Sense appearing on the counsel for the petitioner. Counsel for the petitioner. Praise for time. According case is adjourned. Let the matter appear on 17th September.
Item number 15.
My lord, I am for the Respondent Union of India in this matter. My lord.
Who is for the author petitioner?
My lord, Miss Laboni Pan.
12% per annum, directing the respondent, the agent supporting make payment of
This rate is
compensation.
not maintainable because
What compensation?
my lord, what happened, my lord, in 1972, an act was promulgated, which is the Cooking Coal Mines Nationalization Act 1972. Now, the petitioner who claims to be the owner of the coal mines. Now, in terms of section 26 of the act, the matter relegated to the district judge, Bokaro, to determine the compensation.
Now, my lord, the district judge Bokaro, my lord, he dismissed the petition. Now, my lord, after dismissal of the compensation petition, my lord, by the district judge Bokaro, he filed a representation before the authority and now come out with the writ petition. Now, my lord,
60s.
no, my lord, it was dismissed on 2012. But my lord, the question is that when the statutory tribunal dismissed a proceeding, then my lord, I put a question to myself, how the writ court will interfere?
Fine. They have to challenge this. They
Yes.
are not prepared an
No.
appeal.
No.
District judge under.
My lord, kindly turn to page 16 once.
Yes, I have gone through.
Page 16. This is the order. And the relevant portion is, I'm not troubling my lord to read the entire one. Page 17, last portion.
Yeah,
That
the
on
perusal of
perusal of the record, it is clear that such and such direction has already been given to the applicant to produce the document and oral evidence, but in spite of that, applicant has not been produced any documents nor oral evidence in support of his petition. On the other hand, the state government is the owner of the coal mines by the Nationalization Act of 1972. That the applicant is the only for compensation prior to this act. The applicant is only liable to take compensation prior to the Nationalization Act of 1972, and after coming force of this act, the applicant has no locus standi right title on the coal coking mines. That on the this observation, the suit of the plaintiff is hereby dismissed on contest with cost.
That is 2012.
2012. Thereafter, my lord, they made repeated representation, and now, my lord, in this writ petition, my lord, they are saying that the writ petition, the representation has not been considered, and my lord, praying for compensation since 1960. Now, my lord, the question is, when my lord, that my lord, the tribunal in terms of section 26 has dismissed the claim. Now, certainly, my lord, the question is arose, my lord, that whether the writ court will interfere, how the writ court will interfere.
No, this is an appealable order.
Yes.
That
That
is
is the case.
appealable order. They
That
have
is
not
the
challenged the appeal. 2012, now 13 years have passed. But nobody is here. None appears since appearing for the. You are appearing for whom? State?
No, my lord, the Union of India,
Appearing
1,
for,
2, and 3.
appearing for the respondent 1, 2, and 3. None appears on behalf of the petitioner. Let the matter go out of the list. Next.
Well, instead of my lordship, kindly record my lord, one line of my submission. My lord.
The counsel for the respondent submits that the writ application filed by the petitioner is not maintainable.
As my lord, the civil, my lord, the tribunal
Not
has,
maintainable.
as a lordship.
Item number 17.
My lord, 17
My
similar
lord,
matter.
Similar order as item number 15.
When it is?
17th, my lord, is kept.
As per the prayer made by the counsel for the petitioner, let the matter appear on 17th.
My lord, that respondent number 3 has appeared. Let that be also recorded.
Grateful, your lordship.
Give the name.
Grateful.
Next.
Wait, I have the state respondent lordship in this matter, my lord.
Where is the petitioner? In writ petition, all respondents are appearing, no petitioners are appearing before this
And
court.
sometime next week, lordship will find petitioners appearing, respondent are appearing.
Since appearing for the petition respondent. Respondent number all.
All respondents, state respondent lordship.
Of the state respondents. None appears on behalf of the petitioners. Let the matter go out of the list.
Lordship.
Item number 19.
My lord, I appear for the petition in this matter. My lord, this challenge is, my lord, a show cause notice, my lord.
एक दो ना इतना क्यों देते?
Lord, I appear for the respondent bank. I am being led by Mr. Dewan.
Yes. Who is for the? You are for the petitioner.
My lord, I am led by Mr. Jishnu Chaudhary and my lord, Mr. Sarkar. They're unfortunately, my lord, not available today. My lord, I am only seeking.
What is the matter?
My lord, the matter challenges, my lord, two common show cause notices, my lord, issued under the RBI master direction on frauds, my lord.
this show cause notices, my lord, we are challenging, my lord, the jurisdiction as also, my lord, any step that the bank may take in aid of the show cause notice, my lord, because our contention is that, my lord, the show cause notices are not backed by any document, my lord, and in the documents that we have actually sought for pursuant to orders of coordinate benches of this court, my lord, the other banks, my lord, have not provided us with any of those documents. And in the absence of those documents, my lord, no step can be taken in pursuance of the show cause notices, my lord. That is, in short, my lord, the case that we have made out in the writ petition, my lord.
So, when?
My lord, anything.
My lords, may I request in November, sometime in November, my lords, I'll indicate why. The bank has declared them as fraud back in 2020 for this particular bank. Now, my lords, the writ has been filed in 2025 in March. No steps were taken to upgrade it or to take it up before the predecessor bench was before Justice Amrita Sinha. Now, my lords, the matter is now coming up. My lords may put it up in November after the vacations and we can come back.
My lord, only one indulgence. Kindly record my learned friend's submission that fraud has already been declared, my lord, because that gives us a further argument that raises the contention, my lord, without serving the show cause notice, my lord, we have been declared as fraud.
Let us, my lords may not record, my lords may not record that, my lords, is not perhaps,
The petitioner prays for accommodation. According case is adjourned. Let the matter appear on 24th.
Deeply obliged. But the affidavit of service of the writ petition.
Affidavit of service is kept with 24 September. Huh?
I'm deeply obliged. Great.
Yes. Yes. What is your claim, sir?
The annexer P2 kindly appreciated deed as registration has been completed. But
Item number?
Annexer
Return of original deed.
Original deed. Return of original deed.
What deed?
There, kindly see annexer page, annexer P2, annexer page 18. The IGR.
18.
That on the basis of the return has not been return original.
When it was registered?
Yes.
When it was registered?
1990.
1990.
Lordship.
So?
The original deed has not been returned back. Only things for the moment on information that some of the deeds, my lord, due to the first stamp duty by collected from the vendors. A criminal case is pending before this pending long back. Now what's happened, my lord, by virtue of that the original deeds are lying with this custody. Now the similar circumstances, some of the matters are already disposed of by the granting the deficit. Similar amount has been similar stamp duty already deposited, then returns. I got is written. I got my lord the order. Similar circumstances. The prayer has been considered delivering the written judgment.
There is a common order on this issue. The Lordship know that Telgi stamp scam was there in the country. So that ripple effect was felt in Bengal also at that point of time. So a large number of deeds were found that most of them were written on forged stamp paper. So now police cases were registered in different districts of West Bengal. This is Purvo Mindapur is also one such district where a large number of cases are registered. And all these deeds were seized. Now, thereafter, since these people, hopeless people, they have been waiting since long, that criminal case has not yet ended. So what they have started coming before this honorable court. Now, this issue went up to a division bench. So, honorable division bench was pleased to hold that, yes, you deposit the equal amount of this forced stamp which is being calculated, deposit with the treasury, keep it with them. Treasury will return you, there's a DR, district register will return your deed and let the criminal investigation go on. In the meantime, if it is found after final conclusion that it is they were forged, that amount will be forfeited by the government. If it is found no, it was genuine, then that amount will be returned to you. So my learned friend has handed over a judgment, an order, but this is also single bench, but division bench order has been quoted in this particular, which I am placing, my lord. It will be better, my lord, to kindly have a look to this order. I can, my lord, place my lord, the printout I have sent for. I can put it on your lordship's court record also. This order quotes the division bench judgment. Lordship kindly sees.
Similar thing.
Similar issue, but it has quoted the division bench judgment of our honorable court. The prayer for supplying certified copy of the deed which was registered before the district register Purvo of Medinipur. It appears the said deed was impounded by the police as fake stamp papers were used for preparation of the deed in Potashpur PS case number so and so. Order passed in a similar matter by coordinate bench of this court on 1st November so and so. It appears that the issue has been decided by the Honorable Division Bench of this court on 5th January 2011 in FMA number 200 of 2010. Operative portion of the order passed by the Honorable Division reads as follows. On depositing an amount equivalent to the aggregate value of the stamp papers used for the purpose of registration with the registering authority, and upon proper application being made for obtaining certified copy, and on payment of the proper fees for the same, the registering authority concerned shall supply the certified copy of the document. The said certified copy shall be used for all practical purposes. Supply of certified copy shall be made within fortnight from the date of making deposit. If no deposit is made within 4 weeks from the date of receipt of certified copy of this order, then the issue will be closed chapter and the judgment and order of the learned trial judge will stand revived. The aforesaid amount shall be kept deposited till the investigation is complete and the trial is over, ideally in a term deposit, if possible. If it is found in the trial that the stamp papers in question are forged, then the amounts so to be deposited with the registering authority shall be handed over to the appropriate authority, namely the state government. In the event it is found that the stamp papers are genuine, obviously the amounts so to be deposited shall be returned to the applicant's petitioner. As it appears, the facts of the instant case are similar to the facts so and so. The order passed by division bench shall apply in respect to instant case. Instruction by ADS we kept on. Here also I carry an instruction area. This is a hard copy, Lordship, of this, which I was reading from the device. So Lordship may pass this in the same line, Lordship. And this ADSR report also I am putting on record, Lordship. It has been sent by the ADSR Quantai.
Yes.
Similar order.
Similar order.
The petitioner has filed the present state application praying for a direction for supply of original deed on payment of equal stamp duty. Full stop.
But this will not be original deed, certificate copy will be given.
Original deed on stamp duty. Full stop. The petitioner submits that the deed was registered being deed number 1148 of 1990, dated 20 April 1990. But the same was not provided to the petitioner on the ground that a criminal case has been initiated and the trial is pending before the court. Counsel for the petitioner submit that several deeds are pending before the registering authority and not issuing the same to the purchasers. Accordingly, some of the petitioners have filed writ petitions before this court, and this court time to time passes appropriate order. The petitioner has relied upon the judgment order passed by the coordinate bench of this court dated in WPA number 5550 of 2023 within bracket Mainak Hussain versus State of West Bengal and others dated 27 September 2024, wherein this court directed the directed the petitioner to put the money equivalent to the stamp duty with the registering authority, and the registering authority is directed to issue certified copy of the said deed within a period of 6 weeks from the date of receipt of the such money. The coordinate bench also directed that the registering authority will keep the money deposited in an interest-bearing fixed deposit account with the nationalized bank. Learned counsel for the state authorities, state respondent has handed over the report of the additional district sub-registrar Contai dash Roman 2 at Nachinda, Purva Medinipur, wherein it reveals that a deed was registered at the office of ADSR Contai dash Roman 2 being document number 1148 of 1990, and the same is lying with the office of the ADSR. Learned Counsel for the State Authority state respondents has also relied upon the judgment passed by the coordinate bench in the case of Dhirendra Nath Jana versus State of West Bengal and others, passed in WPA number 9737 of 2025, dated 27th of August 2025, wherein the coordinate bench has relied upon the order passed by the Honorable Division Bench in FMA number 200 of 2010, dated 5th of January 2011, which reads as follows. इसको वो कर दीजिए, quote कर दीजिए, लेकर के the counsel for this court find that the petitioner is, the case of the petitioner is squarely covered with the order passed by the coordinate bench of this court dated 27th of September 2024 and the 27th of August 2025 as mentioned supra, comma. Accordingly, the writ petition is disposed of by directing the petitioner to put in the money equivalent to the stamp duty with the registering authority, and on receipt of the said amount, said stamp duty by the registering authority, comma, the registering authority shall issue certified copy of the deed number of the document number 1148 of 1990.
The deed number should be 1448, Lord.
Oh, 1448.
Kindly follow our Miller instruction.
Document number.
Yes.
That's I'm taken.
Yes.
To 1990, pending before the ADSR Contai dash 2 at Nachianda. Full stop. Within a period of 6 weeks from the date of receipt of such stamp duty. Full stop. The registering authority is also directed to keep the money deposited by the petitioner in the interest-bearing fixed deposit account in the nationalized bank. National Bank, and the till the investigation pending before the concerned authority or the trial pending before the court is disposed of. It is charge sheeted or pending inquiry. That's okay.
Nothing, Lordship. Kindly don't mention all these, Miller.
Or disposed of. Full stop. This writ petition disposed of. There will be no order as to cost.
Or the affidavit service we kept.
Affidavit of service filed by the petitioner be kept.
Grateful to your Lordship.
Next. None appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list. Next. कॉल करो, नहीं है petition नहीं है. Next. No order. Next.
23.
No order. Next.
24.
In any matter, both the parties are there.
28, I am for the petitioner.
28.
I am for the petitioner.
You are for the petition. What is the prayer?
Prayer for only for my
Can
lord.
be disposed of. Show the 28.
Kindly, this is. 28. This is a simple prayer. Petitioner completed the work order. In terms of the work order, all the payment, final payment has been done, but the earnest money has not been, my lord.
When your work was completed?
My lord, the long back. My lord, this is the 23.
23.
Yes. And all the bills are payment done. Only the earnest money has not been paid.
Payment has been made?
Yes.
What is the earnest money?
Earnest money, my lord, my lord, kindly see the representation page 63.
63?
Yes. The earnest money was not paid, though it is paid, but today I paid for interest for the earnest money.
Earnest money you received?
Earnest money received long after 1.5 years.
So, interest, how it can be?
No,
I am disposing of considering
earnest
this.
money, my money. That
Okay, I am disposing of the representation files.
Affidavit service is kept with record.
Affidavit service file of the petition be kept with the record. The grievance of the petitioner in the present application that even after completion of the work awarded to the petitioner, the respondent authorities have released the earnest money of the petitioner after the period of 1.5 years.
Yes.
1.5 years. Accordingly, he prays for interest upon the delayed payment of the interest money, earnest money to the petitioner. Counsel for the petitioner submits that the work was completed on 15th of March 2023, but the earnest money was released on?
Earnest money released on 24.
When?
27/9/24.
Was released on 27th of September 2024.
26 September.
26 September?
Yes.
26 September 2024. And as such, the petitioner is entitled interest at the rate of 18% per annum from 15 March 2023 to 26th of September 2024. Counsel for the petitioner further submit that the petitioner has made representation to the executive engineer Birbhum, Hooghly Division 1, PW within bracket Roads Directorate, Sadak Bhavan, Lambodharpur, Suri, Birbhum, West Bengal on 25th of November 2024. But till date, the representation filed by the petitioner has not been disposed of. Consider the submission made by the counsel for the petitioner. This court find that the only grievance of the petitioner with regard to the delayed interest for release of the security amount of the petitioner. This court find that no purpose should be served by keeping the writ petition pending. Accordingly, the writ petition is disposed of by directing the executive engineer Birbhum Hooghly Division -1 to consider the representation of the petitioner dated 25th November 2024 and to pass a reasoned order. And if the executive engineer finds that the petitioner is entitled to get the interest, same be released. Consider the petitioner of the consider the representation of the petitioner within a period of 6 weeks from the date of representation of this order and to communicate the decision to the petitioner within a week thereafter.
The appeal service kept in record.
Already recorded. WPA disposed of. Next.
Service to
Item number 37.
37. In between, anybody is there?
29. I'm next item 29.
29. Give the 29.
The matter relates to grant of license, restaurant can bar license of category 4.1 Now, Lordship, in terms of the 2003 rules.
Bar license.
Yes.
Is there any rule of the government?
Yes, that is the West Bengal Excise selection for new sites and grant of license for retail of sale of liquor and certain other intoxicants rules 2003. There is the rules.
Where is that rule? I will disclose.
Yes, I everything disclosed. My application has been, in spite of approval, subsequently rejected on the basis of the objection of the local people. That is the
Local people.
Local people. Now, Lordship, kindly come. My advertisement, the notification which was issued. That is page 21.
Who is for the other side?
Lordship, I have served. I have handed over the affidavit of service.
Yes, page 21.
Page 21, this is the notification, Lordship, the amended notification. In exercise of the powers conferred under section 50, 85 and 86 of the Bengal Excise Act 1909, now such as governor hereby pleased to make an immediate effect the following amendments. This is the amendment. Now, Lordship, kindly come. Rule 9, sub-rule 1. What was the amendment? That if found, Lordship, kindly come, the collector shall assess the demand of the intoxicants and law and order related issues in the local area. NOC from the concerned commissioner of police would be required for the commissioner area only. If required, in order to prayer may be sent to the excise commissioner West Bengal if satisfied. The excise commissioner West Bengal may send the approval of LOI to the state government, which may grant LOI if all aspects found that the subsequently the excise commissioner of West Bengal shall issue the LOI and initiate the concerned, Lordship, the
collector.
No.
Initiate the concern.
Collector, yes, collector. Now,
intimate the concern collector.
Intimate the concern collector. The guarantee of an LOI shall apply the license of the particular category in a specified area within the Lordship, the issue of such LOI. Now, Lordship, on the basis of the permission of the state of excise commissioner, Lordship, I have to apply for the license. This was the amended, Lordship, the provisions. Now, Lordship, kindly come page 23. This is the collector of excise. I submitted prayer for grant of letter of intent, LOI.
Yes.
Prayer for grant of letter of intent for getting the restaurant cum bar license under category 4 Roman I at the plot number such and such, Laukhali such and such, Lordship, the Sarberia, Agrighati, block Sondeskhali 1, district North 24 Progna, such and such. Now, Lordship, the kindly come the second paragraph. It is to be further mentioned that to grant the letter of intent for setting up the restaurant cum bar, I have paid 50% of the requisite non-refundable requisite fees of rupees 10,000 through GRIPS by such and such, which kindly perused, I hereby enclose following documents of taking necessary actions. Now, Lordship, these are the formalities I have completed. Now, kindly come page 25. This is the Senior Joint Commissioner of Excise, Revenue 3, has issued the LOI. With reference to the above caption subject, I am directed to inform you that the government in the Finance Department, Government of West Bengal, has approved grant of letter of intent, LOI, in favor of Sri Pranab Das, who is the petitioner herein, in this office, e-file number such and such, in the name and style, Das Restaurant cum bar. Now, plot number such and such. Now, for applying the retail foreign liquor restaurant cum bar license under category I of Rule 4 of the rules is published on the notifications amended in the online mode, Lordship, through e-Abgari portal. I am further directed to issue this letter of intent with the validity of 6 months from the date of issue in terms of the third proviso to sub-rule 1 such and such for applying online the category. Now, Lordship, after getting the online, Lordship, the LOI, page 26, my application. Now these are the documents, page 27.
Where is the
I have-
rejection order?
Yes. Now kindly come. I have kindly come this before that, Lordship. I'm just the security deposit. They have page 23. They have accepted the security deposit. And also initial grant fee of new RCB license, page 34, also has been accepted. Initial grant fee for new RCB license.
Yes.
Now, Lordship, kindly come my rejection order at page 36.
34 is?
34 is, Lordship, the
initial grant fee.
Initial grant fee for new RCB license.
Yes.
Now, Lordship, kindly come page 36. Rejection of online application by such and such by Pranab Das for grant of restaurant cum bar license category in the name of style Das restaurant cum bar at the premise of the plot number such and such and such. With reference to the subject read above, this is to inform you that your online application by ID number such and such for grant of restaurant cum bar license in the name of Das restaurant cum at the premises of plot number such and such and such, Sarveria, Agrighata, block Sondeskali, such and such, not 24 Prognas, has been considered and rejected. There is let's see, what is the rejection ground? The strong objection from the local people opening the bar on the ground apprehension of breach of peace and privacy of the inhabitants as per the reports received from this office. Now, this is the rejection order. The rejection order was passed on 12th February 2025.
Yes.
Now, I have, the initial grant fee, the procedure I have completed on 7th April 2024. Now, before this issuance of the rejection order, my first ground is, no so cause, no hearing, chance of hearing has been given to the petitioner. So, LOI has been given. When LOI has been given, after verifying the local area and the requirements of the demand of the local area, the LOI was issued. I completed all formalities. All on a sudden, they have issued the rejection order. Not only that, what is the rejection order? That there is a strong objection of the local people. No documents has been supplied to us. What are the objections has been given to us? Everything, Lordship, suppressing this material fact and without, Lordship, intimating me that these are the reason. What is their reply to this, Lordship, the grounds without giving any chance of hearing? Lordship, the rejection order has been passed. Now, Lordship, kindly come. Rule 9.
Give the book.
Not, I'm handing over the book. But only it is slightly marked, man.
No, no problem.
Konta.
Rule 9.
Rule 9 starts from page 11, my lord, of the rule section. My lord, the below portion, just.
Yes. Yes.
Subject to the instruction of, also kindly count rule 9, sub-rule 1. Lordship, first of all, Lordship, under category 4I, Lordship, kindly come 4, and before that 9, Lordship, kindly come 4, rule 4, I am the category on 4I.
Foreign liquor for consumption.
Yes, on the premises of a restaurant and attached bar and restaurant cum bar. So, Lordship, this is not a selling of the foreign liquor. This is on soft, that is the within the restaurant.
Foreign liquor, the premises, if any, restaurant and attached bar.
Yes. That is not, the foreign liquor shall not be sold outside because
it's not an outlet.
Consumption within the restaurant.
It's not an outlet.
Yes.
Not the outlet.
Not the outlet.
Yes.
Now, Lordship, kindly come rule 9. 1. Subject to such instruction as may be issued by the state government or excise commissioner from time to time, if the collector is of opinion having regard to the general trend of consumption of liquor and other intoxicants as specified in sub-rule 1 of rule 2 of the local area or the adjoining area, that is necessary for grant of license of any member and any number and any category referred in Lordship the clause such and such. Certain new sites within the local area in order to meet the demand of such area or adjoining areas, he shall for the purpose of selecting new sites by the state government under section 30 prepare a preliminary list of such local areas within which in his opinion license of any category should be granted. Now proviso that Lordship provided that in preparing the preliminary list, the collector shall not include therein the sites for the grant of license of the category specified in clause F to M of Rule 4, unless the persons of the company or the firm, the owner of a hotel, restaurant, club, sites, theatre, or other places, public resort, entertainment, who is eligible under the provisions of these rules or any persons any authorized by him makes an application in Form 1 and Form 2 appended to these rules as the case may be with the requisite court fees. Provided further that at the time of processing the proposal of grant of the categories of the licenses mentioned in clause F to M and Lordship of the Rule 4, collector may process the proposal before the completion of the proposed site according to the blueprint plan, but before issuing license, after obtaining approval of the government for selection of the site, the collector shall ask the applicant to acquire the premises or complete the construction within 30 days of receipt of the communication, and only after acquisition or completion within the stipulated time as the case may be, collector shall issue the license. So Lordship, this is the procedure of issuing license. Every procedure I have completed. In arriving at an opinion referred to in Sub-Rule 1, the collector may hold such inquiry as the deem fit, subject to any directions in this regard which may be issued by the state government or excise commissioner from time to time. The collector shall forthwith send the list referred to in Sub-Rule 1 along with his opinion and excise commissioner. The excise commissioner shall thereafter forward the state government list and records and documents sent to him under Sub-Rule 3 as the case may be, and along with his own opinion to the state government. This state government shall finally consider the preliminary list and documents with the opinion forwarded to it under Sub-Rule 4, and if it is satisfied that it is necessary to grant license in the local area in order to meet the demand for liquor or any other intoxicant, it may select local areas for categories and number of licenses referred in clauses A and C to E of Rule 4, and the sites for categories of licenses referred in clauses F to M of Rule 4 for grant of license and communicate the same to the excise commissioner. Provided that before selecting local area and grant of licenses categories referred to in Rule 4, the state government may consider his opinion necessary to obtain the views of the commissioner of the division under whose jurisdiction the local area falls. Now, Lordship, this is the procedure. Under this procedure, my application has been proceeded. Now, Lordship, kindly come Rule 10. All the application for grant of license at a new site mentioned in Rule 4, excluding license of any canteen referred to in Clause M of Rule 4, shall be made in. Lordship, this is not applicable. Application for grant of license at a new site in area selected by the state government shall be invited from the eligible persons of the collector through the public notice, including advertisement, daily newspaper, such and such, such and such. Now, Lordship, for grant of consideration, all the application for grant of license of new sites for categories of license referred to in Rule 4 shall pay along with the application for non-refundable application fee, such and such. Persons eligible. Lordship, this is the 11 I have satisfied. Now, Lordship, section Rule 12 is the restriction for grant of license. Certainly, no license for the retail sale of liquor or any intoxicant in a new site shall ordinarily be granted if a person who is convicted. Lordship, this is not the case. A formal license who was found guilty, this is also not the case. A formal license who was a defaulter, it is also not the case. Now, Lordship, kindly come Rule 13. The collector shall for the for the categories of license specified in clause A and C, C to E and of Rule 4, select a person from the amongst whose application have been received on or after the date of issue of public notice under Rule 10 within the specified in such notice in accordance with the such manner of the state government may direct a special order in this regard to grant a person so that select the license of the category for which the notice has been issued, provided that if the collector fails to select a person for grant of new license at the new site in a local area, collector shall intimate the fact to the excise commissioner, who shall give such direction as the case necessary. On the application made on the proviso of sub-rule 1 of Rule 9, the grant of license of the categories mentioned, the state government select a new site, the collector shall grant the applicant a license on that category in mention above. Notwithstanding anything in the such and such,
Now your case is coming under the purview of 9B.
9B.
9C.
9C, 9 capital C, public grievance.
9C.
9C, A and B.
A and B. 9C.
That, those provisions are in respect of a person. There's a distinction, site and person. There's a distinction, and these are all appealable orders, my lord.
9C.
No, lots of this is a
9C double sure. 9C A or B, public grievance and airport shall cause.
Now, lots of the first of all, lots of this is my first ground. Lots of kindly come my grounds. First ground, please, lots of the rejection. All on a sudden, there is a rejection. Lots of this is absolutely violation of natural justice on the ground that no lots of the notice of hearing has been given. And lots of first of all, lots of the when LOI was given, lots of the I have satisfied all these conditions. In spite of that, Lordship, they have rejected my application on the ground that there is a local objection. No copy of the local objection. Where is the local objection? Nothing has been supplied to me. Why? This is the and so far the appealable order is concerned, Lordship, this is absolutely violation of natural justice. I don't know.
Exception to the principle appealable Whirlpool. There are, my lord, it is a fact, my lord, I cannot improve on the facts. There was no hearing. But this C subject to correction, there is no contemplation.
Not notice has been given.
No, I cannot improve on
because already letter of intent was. Then okay, 9C and here you are the authority. If you have received the objection, then opportunity given. The what are the report he has to be submitted to him.
Maybe a case where this is not a right. My lord, LOI is a step.
No, that's why I'm telling. LOI is given. Subsequent inquiry is to be conducted before issuance of the notification. Correct. So when the inquiry was conducted, it was found. So if it is found that any report against him, so he should be given an opportunity.
Kindly, my lord, kindly. Well, possibly the authorities has not given, possibly because no right is created in favor of the petitioner.
Correct.
Possibly.
I am not on that. Only with regard to this order.
Can you protect the authority to that extent?
The order which has been passed relying upon the complaint
should be handed over.
Should be given to the opportunity of hearing. The grievance of the petitioner in the present application that the superintendent of excise and deputy commissioner of revenue, not 24 Parganas within bracket rural excise district has rejected the request of the petitioner for grant of application, grant of license for restaurant cum bar on the ground that there has been and there on the ground that there is a strong objection from local people against opening of the bar on the ground of apprehension of breach of peace and privacy of inhabitants as per reports received by the office of the superintendent of excise. The petitioner says that the petitioner has applied for grant of bar license. On receipt of the request made by the petitioner, letters of intent was issued after conducting inquiry, and the petitioner has deposited initial grant fee of rupees 4 lakhs for new RCB license. After the issuance of LOI, the superintendent of exercise has conducted the inquiry, and on receipt of the objection from the local people for opening of the bar, the exercise of the superintendent of exercise rejected the claim of the petitioner. This court find that the exercise of commissioner has rejected the request of the petitioner on the strong objection from the local people for opening of the bar in terms of clause. It is section or clause?
Clause, my lord. These are part of the rules.
Clause 9 within bracket capital C within bracket small a and within bracket small b of the West Bengal excise within bracket selection of new sites and grants of license for retail sale of liquor and certain other intoxicants bracket close rules 2003. This court considered the grievance of the petitioner and found that the superintendent of exercise has rejected the request of the petitioner only on the ground of strong objection from the local people against the opening of the bar on the said locality. But the concerned authority has not given an opportunity of hearing to the petitioner, and the objection received by the superintendent of exercise was not supplied to the petitioner. Thus, this court is of the view the order passed by the superintendent of exercise is violation of natural justice. Accordingly, for the said on the said reason only on the said reason, this court set aside the impugned order dated 12th February 2025 passed by the superintendent of exercise. Full stop. However, the superintendent of exercise is directed to reconsider the request of the petitioner for grant of license for opening of bar restaurant cum bar license after giving an opportunity of hearing to the petitioner by supplying the objection received by the office of the superintendent of exercise from the local people against the opening of the bar by the petitioner in the said locality. The superintendent of exercise shall complete the said process within a period of 6 weeks.
6 weeks.
6 weeks from the date of receipt of this order. The superintendent of police is directed to pass reasoned and speaking order after giving an opportunity of hearing to the petitioner within a period of 6 weeks and to communicate the order to the petitioner within a week thereafter.
Superintendent of police, it has
exercise.
Exercise.
With the above observation, WPA 7039.
I'm grateful.
Thank you. That's all. Anything?
Number 34, my lord.
31.
31 also. What is the matter?
I make to appear for the state.
Nobody is the petitioner.
In 34 also, my lord, I am for the state respondent.
Now come tomorrow and next week.
My lord.
Grateful.
You are passing an hour.